It's not available.
Argue on the merits dehorse this non-production of the records as per the order of the court, having regard to the nature of prayer that they saw.
What is there to argue, Mr. Vishankar, now that
Writ
it's not
petition-
available?
Writ petition itself is not maintainable. Kindly see the prayer.
You're ready now?
Yes. If my friend is ready.
Spend enough and more time on this.
Yes. It may take some time, but I'm ready.
How long will you take?
10-15 minutes.
10-15 minutes is nothing.
So far as my is concerned, my takes half an hour time, my lord. Takes time. Matter required to be consideration. Because when Kuda Act is forced, my lord, the acquisition
What is
in
this amendment application? Will be considered along with it.
this court.
ನೀವು half an hour ಅಂತೆಲ್ಲ ಹೇಳಿದ್ರೆ ಆಗಲ್ಲ. We'll release it, let it go before this one. How much time?
ಅಷ್ಟು ಕೇಳಿದಿರ ತಮ್ಮಂದೆ ನಮ್ಗೆ ಯಾವತ್ತಾಗುತ್ತೋ every day I am
Released on 18th. It's made clear that no further adjournment will be granted.
Please, my lord, in so far as my lord,
Both the councils are directed to file their respective list of synopsis of dates and events, list of authorities, along with synopsis of arguments.
please, my lord. In so far as my lord, state ಗೆ ಇದ್ ಮಾಡಿದ್ರಿ ಇದನ್ನ ಅವಾರ್ಡ್ ಡೆಪಾಸಿಟ್ ಮಾಡಿದ್ರಿ ಇಲ್ವಾ ಅಂತ that make it clear, my lord. This court, my lord, earlier
That
occasions.
Mr. Vishankar wants to address.
Please.
Serial number 7, my lord. 7.
Yes, 7, Mr. Sharma.
Yeah, my lord, of course, I adopt all other statements. In fact, I had amended the petition on 7. That amended is subsequently they passed a resolution that is also challenged by me. Election MNO. That's all by addition. That's all. All others are same.
Your name is not shown, Mr. Sharma.
Yes, it is there. Last number. Your last number, I am for the petitioner.
Serial number 9, sir.
That is serial number 9, not 7.
9. Oh, I am sorry, my lord. I'm sorry. I'm serial number 9.
Serial number
I got it.
Manjunatha LS and connected matter.
Yes, Mr. Ravishankar, what happened?
ಅವ್ರು 9 ಅಂತ ಕಾಣ
ಅದು ಬೇರೆ, ನಿಮ್ದು ಬೇರೆ. ಇವಾಗ ನಿಮ್ದು 8.
ಇದರಲ್ಲಿ WP number 26014 of 2025. What's relief sought for was that the Bar Council should not give any no objection certificate or letter of affiliation or recognition to any other association.
Settlement has not happened.
That didn't happen, but this prayer has become infructuous because, of course, there is a memo which is filed.
26014, Rohit Kumar.
Rohit, yes, this 26014,
You are
I am
for
for
the-
the association.
For the petitioner.
Yes. Can I just,
So you are sought for to not issue certificate letter of affiliation.
although the Bar Council on 6/12/2025 has already passed a resolution. Minutes, now I am passing on with the memo, minutes. So in view of this memo, the resolution passed, minutes, the writ petition prayers will not survive for consideration.
8.1, petitioner is before this court seeking for the following reliefs. A memo dated 28/7/26 has been filed, which reads as under. Along with the said memo, the extract of the resolution of the Bar Council dated 6/12/25 has been produced, which is enclosed, which is extracted hereunder for easy reference. Shri D.R. Ravishankar, learned senior counsel appearing for the petitioner, submit that in view of the said resolution and on account of the adoption of the common bylaws by the Advocates Association Bengaluru and the recognition already granted by the Bar Council of Karnataka, the relief sought for in the above petition have been rendered infructuous. Placing his submission on record, WP number 26014 of 24 is dismissed as infructuous.
Lord, may I make a submission?
8.2.
That respondent, I appear for the respondent number 3, my lord. In that last occasion, the person who was elected had issued the notification memo.
They are withdrawing it as infructuous. How is your?
Yeah, withdrawing.
He wanted to be still there. Yes. What about 8?
Because
8.1, it is WP 26743 of 2025.
8.1 is 26014.
2674.
Nimdu 2673. 8.2 Nimdu.
Other 8.2.
8 Manjunath.
That is for 27952,
279.
petition on that case.
Yes. Ready in this?
26743.
Lords, 26743 and 27952 of 2025, there are two more petitions. Lords, this 26743, Milords, is filed by High Court Bar Association, Milords, that the association should be restrained from taking any precipitative action. Your Lords were to see, Milords, the prayer sought for.
Which one do you want us to say? 26743 or
Milords, your Lords
27?
may kindly have 26743 of 25.
26743.
Yes. Milords,
Other than
there,
that, I have
what
paper
has happened,
respondent.
Milords, is most of the persons who had constituted, they have already given a letter to us. We have to place that, those letters before your Lordships, saying that we are not interested in pursuing this association. Lords, by placing that on record, Milords, I think even this matter could be closed. Because whoever were the constituents, now the minimum requirement to constitute an association is 7. Now, whoever were subscribers to the memorandum of association at the first instance, most of them have already given a letter which reduces it beyond 7. So that, Milords, I have to place it before your Lordships. I have told Milords, the association will file it along with a memo.
Already the respondents withdraw their resolution undertaking before the Honorable High Court, not to suspend any.
We will not, that
association.
of course, not at all.
That also stayed by this Honorable Court, as well as they may be association withdraw this resolution to suspend the members of the association. But taking the
Well, sir.
undertaking before this Honorable Court, if he agreed to that undertaking, that is memo may be filed, petition may be disposed of.
In what is your submission? Mr.
Illa, now yarno,
Then suspend the advocate association.
whoever, Milords, I just
16 members have been suspended. The new one.
16 members have been suspended.
was,
Earlier members of the
Members
old
of the
association
old
have been
advocate
suspended.
association.
Milords, it
Not
was.
revoked.
Not
Actually,
revoked.
really,
That revoked, they may be revoked,
Let's-
but it may be undertaking given before the Honorable Court, they revoke the advocate association.
so suspension of membership of the Advocate Association Bengaluru,
Bengaluru.
Page,
16 jana.
16 ಜನ ಇದ್ದಿದ್ದು ಹೈಕೋರ್ಟ್ ಅಡ್ವೊಕೇಟ್ ಅಸೋಸಿಯೇಷನ್ ಮೆಂಬರ್ಗಳು. ಅಡ್ವೊಕೇಟ್ ಅಸೋಸಿಯೇಷನ್ ಈ ಮೆಂಬರ್ಗಳನ್ನ ಏನಪ್ಪ ಅಂತಂದ್ರೆ ಅಡ್ವೊಕೇಟ್ ಅಸೋಸಿಯೇಷನ್ ಈಗಿರೋ ಹಳೆ ಅಡ್ವೊಕೇಟ್ ಅಸೋಸಿಯೇಷನ್ ಮೆಂಬರ್ಗಳು ಇದ್ದಾರೆ, ಇವ್ರಿಗೆ ತೆಗೆಯಲಾಗಿದೆ ಅಂತ ಹೇಳಿ ಅವರ ರೆಸಲ್ಯೂಷನ್ ಪಾಸ್ ಮಾಡಿದ್ರು. ಅದನ್ನ ಅವ್ರು ಇಲ್ಲಿ ಅಂಡರ್ಟೇಕಿಂಗ್ ಕೊಟ್ಟು ಹಾನರಬಲ್ ಕೋರ್ಟ್ ಮುಂದೆ ಇಲ್ಲ ನಾವು ಅದನ್ನ ನಾವು
Implement ಮಾಡಲ್ಲ.
ಇಂಪ್ಲಿಮೆಂಟ್ ಮಾಡಲ್ಲ, ನಾವು ಏನಪ್ಪಾ ಅಂದ್ರೆ ಅದು ರೆಸಲ್ಯೂಷನ್ ವಿಡ್ರಾ ಮಾಡ್ಕೋತೀವಿ ಅಂತ ಹೇಳಿದ್ರು.
ಇಲ್ಲ, ಇಲ್ಲ,
If the resolution will be withdrawn before
I'll-
they file the memo, before this Honorable Court, that may be infracted. That's all.
I'll just clarify this.
Let's
Lordships
start.
may kindly,
Please.
kindly have
ಹೇಳಿದ್ಮೇಲೆ ನೀವು ಹೇಳಿ
page number 60,
ಏನ್
Milords.
ಹೇಳ್ತಾರೆ ಕೇಳಾದ್ರು ಕೇಳ್ಕೊಳ್ಳಿ.
My lord,
We have not
ಒಂದ್ ನಿಮಿಷ
suspended,
ಇರಿ, ಒಂದ್ ನಿಮಿಷ
Milords,
ಇರಿ.
we have not suspended any of the members. What we said is, since you are doing this, kindly have a look at page 60.
Let us hear the petitioner's grievance first, then we'll come to you.
Very well.
Yes,
my lord, respondent number 3, Mr. Amurtesh is not feeling well, my lord.
respond number 3 ನಿಮ್ದೇನಿಲ್ಲ ಬಿಡಿ. Petitioner,
ಅವ್ರು ಇದು
what is the
ಕೊಡ್ತಾ
grievance?
ಇದ್ರಲ್ಲಿ-
That is the only grievance.
Press briefing ಕೊಡ್ತಾ ಇದ್ರಿಲ್ಲ ಹೊರಗಡೆ ಒಂದು.
ಹಾ.
ಹೌದಾ?
ಬ್ರೀಫಿಂಗ್ ಕೊಡ್ತಾ ಇದ್ರಂತಲ್ಲ ಅಮೃತೇಶ್ ಕಾರಿಡಾರ್ ಅಲ್ಲಿ.
ಇಲ್ಲಿ press briefing ಕೊಡ್ತಾ ಇದ್ದಂಗೆ ಕಾಣಿಸ್ತಪ್ಪ ಅಲ್ಲಿ ಕಬ್ಬನ್ ಪಾರ್ಕ್ ಹತ್ರ.
ಆಯ್ತು ಹೇಳಿ,
Not
now
feeling
you
well.
can tell.
Milords, kindly see annexure H, page 60, Milords.
Yes,
Milords, paragraph number 2, we never suspended them. We said, you resign and issue show cause notices to expel them ಅಂತ ನಾವು ಕಳಿಸಿದ್ವಿ. ಇದಾದ್ಮೇಲೆ some of them have come forward and they have given the letters. Those letters I have to place it before Lordships. If those letters are taken into account, that minimum number of 7 is not there. It falls below number 7, Milords, and probably we will be requesting your Lordships, Milords, to even cancel the registration because it's fallen below 7. The registration has to go.
Annexure H ದಲ್ಲಿ ಏನಪ್ಪಾ
Suspension we are not doing, Milords, of course, much water. We are not doing any suspension. We have said it already. We are not
that
suspending.
is what Mr. Danappa is saying. If you are making that submission that you are not suspending or terminating the membership of anybody, he'll withdraw the above petition as infructuous.
That's all, that's
Milords,
all,
it is not an unconditional statement which I am making because I stand by what is there in the resolution, Milords.
He is happy with your submission.
Yes, no,
Yes, yes,
as of,
yes, my lord, yes, my lord, yes, my lord.
as of now, we have not suspended anyone and we have not terminated and expelled anyone from the membership. We are only indicating that pursuant to our letter dated 29/8/2025, there are some members who actually were part of the formation of a new association. They have come to the association, they have given a letter saying that we are resigning and we are not going to be part of that. Those letters, we will place it before a lordships and seek for appropriate
Not
orders.
necessary.
My lord, Annexure
If you are
H.
saying that you are not suspend anybody.
No,
and you
that's
are
not
going to-
unconditional, my lords.
But
It is not unconditional because it should not happen that the statement which I am making is contrary to the resolution passed by the general body.
You have not suspended or you will not suspend anybody in connection with the formation of the High Court of what is it?
High Court of
High Court Bar Association is
My lords,
satisfied.
we have stated, my lords, that if they resign and desist from formation of the new association, then we will not take any action against them. If they pursue with that, my lords, we want to take action because it is an anti-association activity. We can't take it, it's a misconduct.
My lord, only question is, my lord, the association members are not suspended by this advocate association. They undertaking given before this honorable court, they withdraw the association membership. That is only.
Do you want to continue with the formation of the
They make a statement.
That is the advocate association.
Mr. Danappa?
Yes, my lord, that is
Do
the
you-
third question, my lord. That is the third question.
First hear the question before you answer.
ಆಯ್ತು,
Question ನೀವು ಕೇಳಿಲ್ಲ ಅಂದ್ರೆ ಆನ್ಸರ್ ಏನ್ ಮಾಡ್ತೀರಾ?
ಆಯ್ತು, ತಿಳಿಸಿ.
ಇನ್ನ ಕ್ವಶನ್ ಪೇಪರ್ ಸರ್ಕ್ಯುಲೇಟ್ ಆಗಿಲ್ಲ, ನೀವು ಲೀಕ್ ಅಂತೂ ಬಿಡಿ. ಲೀಕ್ ಆಗಿತ್ತಾ?
ಎಂತದು ಏನಿಲ್ಲ ಸಮಯ.
Do you want to continue with the High Court Bar Association?
ಹಾ, they may be.
Continue ಮಾಡಬೇಕು ಅಂತ
ನಿಮ್ದು ಹೇಳಿ.
Advocate association.
High Court
he may
Bar
be
Association
advocate council.
ಕಂಟಿನ್ಯೂ ಆಗ್ಬೇಕು ಅಂತ ನಿಮ್ಮ
He may be council. ನಿಮ್ದು.
ಅದು ನನ್ನ ನಂಬರ್ ಬೇರೆ.
Continue ಮಾಡ್ಬೇಕಂತಾನೆ ಇದೆ. That's why Amritesh wants to appear.
then Mr. Ravi Shankar is right, it can't be unconditional. Then we'll have to hear you. So you argue the matter, then we will consider. New one side settlement is two-way traffic, not one way.
ಆಮೇಲೆ ಅಲ್ಲ, ಆ ಪ್ರಶ್ನೆ ಬರಂಗಿಲ್ಲ ಸಮಯ. ಅಲ್ಲಿ ಪ್ರಶ್ನೆ ಬಂದಿದ್ದು ಏನು ಅಂತ ಅಂದ್ಬಿಟ್ರೆ, ಇವ್ರು ಅನೆಕ್ಸರ್ ಎಚ್ ಏನಪ್ಪ ಅಂದ್ರೆ ನಾಟ್ ಟು ಯುಟಿಲೈಸ್ ದಿ ಪ್ರಿಮಿಸಸ್ ಆಫ್ ದಿ ಹೈಕೋರ್ಟ್ ಬಿಲ್ಡಿಂಗ್ ಇನ್ಕ್ಲೂಡಿಂಗ್ ಟಾಯ್ಲೆಟ್ ಎನಿಥಿಂಗ್. ದಟ್ ವಾಸ್ ಕ್ವಶನ್ ಬಿಫೋರ್ ದಿ ಹಾನರಬಲ್ ಹೈಕೋರ್ಟ್. ಅಷ್ಟೇ, ಅಲ್ಲಿ annexure H ಇರೋದು ಅದನ್ನೇ ಸ್ವಾಮಿ ಅಲ್ಲಿ ಇರೋದು.
Whatever,
ಅದು ಅಂತದೇನು ಮಾಡ, ಅದಕ್ಕೆ ನಾನು ಪಿಟಿಷನ್ ಫೈಲ್ ಮಾಡಿದ್ದೆ ಸ್ವಾಮಿ, ಅಷ್ಟೇ, ಅಲ್ಲಿ ಏನಿಲ್ಲ ಅದ್ರಾಗ.
ಜಗಳ ಆಡಕ್ ನೀವಿದ್ದೀರಾ, ಕೇಳಕ್ ನಾವಿದ್ದೀವಿ.
ಅದು ಬೇಡ ಬೇಡ ಅಂತ
Decide
ಹೇಳ್ತಾರೆ.
ಮಾಡ್ತೀವಿ.
ಅವ್ರು ಯಾವಾಗ ಹೇಳಿದ್ರು
ಅದೇನಿದಿಲ್ಲ.
ಪ್ರಶ್ನೆ ಇಲ್ಲ ಸ್ವಾಮಿ, ಅಷ್ಟೇ ಸ್ವಾಮಿ, ಅಲ್ಲಿ ಏನಿರೋದು.
You are making only, you are asking them for one concession.
ಕ್ವಶನ್ ಅಸೋಸಿಯೇಷನ್ ಇರ್ಬೇಕೋ ಬೇಡ ಅನ್ನೋದು ಕ್ವಶನ್ ಇವಾಗ.
ಹಾ, ಸೊ ನೀವು
ಅದು
ಇರ್ಬೇಕು ಅಂದ್ರೆ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿ, ಅದನ್ನ ಇಲ್ಲ ಅಂದ್ರೆ they are ready to give that undertaking.
Yes.
That's what they are saying.
ಈ ಅಸೋಸಿಯೇಷನ್ ಇರ್ಲಿಕ್ಕೂ ಇವ್ರ ಅಂಡರ್ಟೇಕಿಂಗ್ ಕೊಡ್ಲಿಕ್ಕೂ ಸಂಬಂಧ ಇರಂಗಿಲ್ಲ ಸ್ವಾಮಿ.
Then argument ಕೇಳ್ಬೇಕಪ್ಪ.
ಅಲ್ಲ, ಅದು
We can't say undertaking.
ಅಸೋಸಿಯೇಷನ್ ಇರ್ಲಿಕ್ಕೂ ಇವ್ರು ನಮಗೆ ಹೆದರ್ಸಿ ಏನಪ್ಪಾ ಅಂದ್ರೆ ಅಸೋಸಿಯೇಷನ್ ಮೆಂಬರ್ಸ್ ಗಳನ್ನ ತೆಗಿದಕ್ಕೂ ಇಡ್ಲಿಕ್ಕೂ ಇದು ಪ್ರಶ್ನೆ ಬರಂಗಿಲ್ಲ ಸ್ವಾಮಿ.
ಇವಾಗ ನೀವು ಒಂದ್ ಪ್ರಪೋಸಲ್ ಕೊಟ್ರಿ, ಅವ್ರು ಅದಕ್ಕೆ ಒಪ್ತಾ ಇದಾರೆ, ಅವ್ರು ಇನ್ನೊಂದು ಹೇಳಿದಾರೆ ನಿಮ್ಗೆ, ನೀವು ಅದು ಒಪ್ಪಂಗಿದ್ರೆ ನಿಮ್ ಸೆಟಲ್ಮೆಂಟ್ ವಿಲ್ ರೆಕಾರ್ಡ್.
ಈಗ ಅಸೋಸಿಯೇಷನ್ ಇರಬಾರ್ದು ಅಂತಕೊಂಡು ಹೇಳಿ ಮೀಡಿಯೇಷನ್ ಮಾಡಿದ್ರು ಸ್ವಾಮಿ, ಸೀನಿಯರ್ ಕೌನ್ಸಿಲ್ ಮುಖಾಂತರ
ಸೆಟಲ್ಮೆಂಟ್ ಆಗ್ಲಿಲ್ವಲ್ಲ,
ಅದು
Failed man.
ಅವರು ಕೋಆಪರೇಷನ್ ಕೊಡ್ಲಿಲ್ಲ, ಇವರು ಕೋಆಪರೇಷನ್, ನಾವು ಕೋಆಪರೇಷನ್ ಕೊಟ್ಟಿಲ್ಲ ಅಂತ.
ಬಿಟ್ಬಿಡಿ. ನೀವೊಂದ್ ಪ್ರಪೋಸಲ್ ಕೊಟ್ರಿ, ಅವ್ರು ಒಪ್ತಾ ಇದಾರೆ, ಅವ್ರೊಂದ್ ಪ್ರಪೋಸಲ್ ಕೊಟ್ಟಿದ್ದಾರೆ, ನೀವು ಒಪ್ತಾ ಇಲ್ಲ. ಸೊ ವಿಲ್ ಹ್ಯಾವ್ ಟು ಹಿಯರ್ ದ ಮ್ಯಾಟರ್, ಆರ್ಗ್ಯೂ ದ ಮ್ಯಾಟರ್, ವಿಲ್ ಪಾಸ್ ವಾಟ್ ಎವರ್ ಆರ್ಡರ್ ಇಸ್ ರಿಕ್ವೈರ್ಡ್ ಟು ಬಿ ಪಾಸ್ಡ್.
ಆ ಕಾನ್ಸ್ಟಿಟ್ಯೂಷನ್ ರೆಮಿಡಿನಲ್ಲಿ ಅಸೋಸಿಯೇಷನ್ ಎಸ್ಟಾಬ್ಲಿಷ್ಮೆಂಟ್ ರೈಟ್ಸ್ ಇದೆ ಸ್ವಾಮಿ, ಅದನ್ನ ಅಷ್ಟೇ
ನೀವು ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಲ್ವಾ?
ಅಷ್ಟೇ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ತೀವಿ ಸ್ವಾಮಿ,
ಮತ್ತೆ ಮಾಡಿ.
ಅಷ್ಟೇ ಸ್ವಾಮಿ, ಅಷ್ಟೇ. ಅಲ್ಲಿ
ಮಾಡಿ, ಏನ್-
ಅಸೋಸಿಯೇಷನ್ ಬಾರ್ ಅಸೋಸಿಯೇಷನ್ ಏನಪ್ಪಾ ಅಂದ್ರೆ ಇರ್ಬೇಕಂತ ಹೇಳಿ ನಿರ್ಣಯ ಮಾಡಿದ್ದಾರೆ.
ವಾಟ್ ಈಸ್ ಯುವರ್ ಸಬ್ಮಿಷನ್ ಇನ್ ಇದ್ಯಾವುದು 26743 ಅಲ್ಲ? 26743 ನೀವು
ಇಲ್ಲ 26743. It is only regarding the annexure H, my lord, that's all.
correct.
Not by the- not-
What is your submission?
My lord, according to our writ petition, my lord, that is annexure H, that may be withdrawn by the Advocate Association Bangalore. That is, my writ petition is infraction, that's all, my lord. Regarding this prayer, my writ petition is infraction.
They are not ready to withdraw unless you submit that you won't continue with this association. That is what they are saying.
ಈ ಪ್ರಶ್ನೆಯಲ್ಲಿ ಬರಂಗಿಲ್ಲ ಸರ್, ಕಂಟಿನ್ಯೂ ಮಾಡ್ಬೇಕನ್ನೋದು ಈ ರಿಟ್ ಪಿಟಿಷನ್ ಅಲ್ಲಿ ಬರಲ್ಲ ಸ್ವಾಮಿ, ಅಷ್ಟೇ. ಈ ಕ್ವಶನ್ ಇಲ್ಲ ಸ್ವಾಮಿ ಅದ್ರಲ್ಲಿ.
They are not ready to give that concession to you. So you have to argue on merits. Are you ready to argue merits? You please argue.
My submission is.
ಬರೋದೇನಪ್ಪ ಅಂದ್ರೆ ನಾನ್ ರಿಪಿಟಿಷನ್ ಹಾಕಿದ್ದೆ ಅದು ಸಮಯ ಅವ್ರು ವಿಡ್ರಾ ಮಾಡಿದ್ಮೇಲೆ ಈ ರಿಪಿಟಿಷನ್ ಇನ್ಫ್ಲೆಕ್ಸಸ್ ಆಗುತ್ತೆ ಸರ್ ಅಷ್ಟೇ ನಾನು ಹೇಳ್ತೇನೆ.
ಯಾವುದು
ಅದೇ 262743/2025 ಅದು ಇನ್ಫ್ಲೆಕ್ಸಸ್ ಆಗುತ್ತೆ ಸ್ವಾಮಿ. ಅವ್ರು ಅಂಡರ್ಟೇಕಿಂಗ್ ಕೊಟ್ಟ ಮೇಲೆ ಅನೆಕ್ಸರ್ ಎಚ್ ನಲ್ಲಿ
ಅವ್ರು ಕೊಡಕ್ ರೆಡಿ ಇಲ್ಲ.
ಇಲ್ಲ ನಾವು ಹೇಳಿದ್ರೆ ಸ್ವಾಮಿ ಬಿಫೋರ್ ಅಂಡ್ ಲಾಸ್ಟ್ ಮೂಮೆಂಟ್ ಕೂಡ ಏನಪ್ಪಾ ಅಂದ್ರೆ ಹಂಡ್ ಬಲ ಕೊಟ್ಟು ಅಂಡರ್ಟೇಕಿಂಗ್ ಕೊಟ್ಟು ನಾವು ಯಾವ ಅಡ್ವೊಕೇಟ್ ಅಸೋಸಿಯೇಷನ್ ಮೆಂಬರ್ಸ್ ಸಸ್ಪೆಂಡ್ ಮಾಡಲ್ಲ ಅಂತ.
That was subject to mediation.
ಇಲ್ಲ ಸಬ್ಜೆಕ್ಟ್ mediation ಸ್ವಾಮಿ ಬಿಫೋರ್ ಅವ್ರು ಏನಪ್ಪಾ ಅಂದ್ರೆ ಅಂಡರ್ಟೇಕಿಂಗ್ ಕೊಟ್ಟಿದ್ದಾರೆ. Mediation ಅಲ್ಲಿ ಇಲ್ಲ
ನೀವು
ಸ್ವಾಮಿ,
ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ತಿರೋ ಇಲ್ವೋ ಡಿಸ್ಮಿಸ್ ಫಾರ್ ನಾನ್ ಪ್ರಾಸಿಕ್ಯೂಷನ್ ಮಾಡ್ತೀವಿ. ನೀವು ಏನ್ ಇಂತ ಸಬ್ಮಿಷನ್ ಮಾಡಿದ್ರೆ
My lord.
ಸ್ವಾಮಿ mediation ಹೋಗಕ್ಕಿಂತ ಮುಂಚೆನೆ ಅವರು ಅಂಡರ್ಟೇಕಿಂಗ್ ಕೊಟ್ಟಿದ್ದಾರೆ ಸ್ವಾಮಿ ಕೋರ್ಟ್ ಮುಂದೆ. ಅವ್ರು ವಿಡ್ರಾ
ನೀವು
ಮಾಡ್ಕೊಂಡಿದ್ದಾರೆ.
ಯಾರಿಗೆ who are you in 26743? Are you a party in 26743, Mr.
No,
Counsel?
he has not party, my lord. Only association is party, no rights.
Are you a party in this matter?
No rights to.
He's not.
He is not.
Then don't interfere, don't
Don't
interrupt,
interfere,
don't
my
try
lord.
to
Let's-
say anything. Very good, happy. Your resignation accepted.
Out of 21,
My lord, one submission.
ಮಾಡಂಗಿದ್ರೆ ಮಾಡ್ಲಿ ನಂದೇನು
Have it next week, my lord. Amritesh will come in argument.
ಇದ್ರಲ್ಲಿ ಏನ್
26743/25 may be disposed the infractions because their resolution passed by the annexer H as well as suspended the advocate association, they are withdrawn.
ಒಂದ್ಸತಿ ಅವ್ರಿಗೆ ಹೇಳ್ಬಿಡಿ, ನಾನು ಕೇಳ್ತಾ ಇಲ್ಲ ಅವ್ರು ನೀವೇನ್ ಮಾಡ್ತೀರಾ ಅಂತ ಹೇಳಿ.
ಸರ್ ಇದು ಅಲ್ಲ ಹೇಳ್ಬಿಡ್ತೀನಿ.
ಹೇಳಿ.
ನೀವು ಹೊಸ ಅಸೋಸಿಯೇಷನ್ ಮೆಂಬರ್ಸ್ ಹೊಸ ಅಸೋಸಿಯೇಷನ್ ನೀವು ಪರ್ಸ್ಯೂ ಮಾಡ್ತೀವಿ ಅಂತ ಹೇಳ್ತಿದ್ದೀರಲ್ಲ, ಅದನ್ನ ಕೈ ಬಿಟ್ರೆ ನಾವು ರೆಸೊಲ್ಯೂಷನ್ ವಿತ್ಡ್ರಾ ಮಾಡ್ಕೋತೀವಿ, ಯಾರನ್ನೂ ಸಸ್ಪೆಂಡ್ ಮಾಡೋದಿಲ್ಲ ಅಂತ ಹೇಳಿರೋದು. ರೆಸೊಲ್ಯೂಷನ್ ನೀವು ಚಾಲೆಂಜ್ ಮಾಡಿರೋದು ಅದನ್ನೇ, ನೀವು ಚಾಲೆಂಜ್ ಮಾಡಿರೋ ರೆಸೊಲ್ಯೂಷನ್ ಅದು.
ಸರ್ ನಮಗೆ ಅರ್ಥ ಆಯ್ತು ಸ್ವಾಮಿ, ಅವ್ರು ಹೇಳ್ತಾರದೇನ
ಕಂಡೀಷನಲ್ ಆಫರ್
ಅವ್ರ ಅರ್ಥ ನಮಗೆ ಅರ್ಥ ಆಯ್ತು ಸ್ವಾಮಿ. ಪ್ರಶ್ನೆ ಬಂದಿದ್ದೇನು ಅಂತಂದ್ರೆ ನಾವು ಅಸೋಸಿಯೇಷನ್ ಇದನ್ನ ನಾವು ವಿಡ್ರಾ ಮಾಡ್ಕೊಂಡ್ರೆ ಅವರು ರೆಸೊಲ್ಯೂಷನ್ ಏನಪ್ಪಾ ಅಂತಂದ್ರೆ ನಾವು ಸಸ್ಪೆಂಡ್ ಮಾಡಿದ ಮೆಂಬರ್ಸ್ ಗಳನ್ನ ಏನಪ್ಪಾ ಅಂದ್ರೆ ಸಸ್ಪೆಂಡ್ ಮಾಡಿದ್ದನಪ್ಪ ನಾವು ಏನಪ್ಪಾ ಅಂತಂದ್ರೆ ವಿಡ್ರಾ ಮಾಡ್ಕೋತೀವಿ ಅಂತ ಹೇಳ್ತಾ ಇದ್ದಾರೆ. ಸಪೋಸ್ ನೀವು ಅಸೋಸಿಯೇಷನ್ ಏನಪ್ಪಾ ಅಂದ್ರೆ ಕಂಟಿನ್ಯೂ ಮಾಡಿದ್ರೆ ನಾವು ಇದರಲ್ಲಿ ಇರ್ತಕ್ಕಂಥ ಏನಪ್ಪಾ ಅಂತಂದ್ರೆ ಮೆಂಬರ್ಸ್ ಗಳನ್ನ ಏನಪ್ಪಾ ಅಂತಂದ್ರೆ ನಾವು ಸಸ್ಪೆಂಡ್ ಮಾಡಿದ್ದನ್ನೆಲ್ಲಪ್ಪ ವಿಡ್ರಾ ಮಾಡ್ಕೊಳಂಗಿಲ್ಲ ಅಂತ ಅವ್ರು ಹೇಳ್ತಾ ಇದ್ದಾರೆ.
ಅರ್ಥ ಆಯ್ತಲ್ಲ. ಸೊ ಇವಾಗ ಅಂತದ್ರಲ್ಲಿ when both of you are not agreeable, how do we dismiss it as infractions? You have to argue the matter.
ಈಗ ಆಯ್ತು ಅಸೋಸಿಯೇಷನ್ ನಲ್ಲಿ ಅವರು ಹೇಳ್ತಾ ಇದ್ದಾರೆ ಸರ್ ಮೆಂಬರ್ಸ್ ಗಳು ರೆಸೊಲ್ಯೂಷನ್ ಪಾಸ್ ಮಾಡ್ತಾರೆ, ಅದ್ರ ಬೇಸಿಸ್ ಮೇಲೆ ಏನಪ್ಪಾ ಅಂದ್ರೆ ಅವರು ಅಸೋಸಿಯೇಷನ್ ಏನ್ ಡಿಸಿಷನ್ ತಗೋತಾರೆ ಅದ್ರ ಮೇಲೆ ನಾವು ಪ್ರೊಸೀಡ್ ಮಾಡ್ತೀವಿ ಸರ್.
ಇವಾಗ ಯಾವಾಗ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ತೀರಾ?
Week, my lord.
8 ಅಲ್ಲಿ ಯಾರಿದ್ದಾರೆ?
I just want to
ರೋಹಿತ್
say this
ಕುಮಾರ್, you
because
are
Mr.
there, ರೋಹಿತ್ ರವಿತ್ ಕುಮಾರ್. 8.2 is Rohit Kumar, Natraj and Amritesh. Yes, when will you address argument?
Another matter.
ಸರ್ ಒಂದ್ ನಿಮಿಷ ಇರಿ, ಇದು ಮುಗಿದ್ಬಿಡ್ಲಿ, ಅವ್ರು ಕೇಳ್ತಾ ಇದ್ದಾರೆ ಯಾವ ತಾರೀಕು.
ಇನ್ನ ಒಂದ್ ಯಾವ್ದು?
27952.
Correct.
In that I am questioning the challenging the district sir impugned entry model.
ಆಯ್ತು. Are you ready for argument today?
Yes, my lord.
ಮತ್ ಮಾಡಿ.
Yes, my lord.
You are ready, argue the matter.
In accordance with law, the petitioner, High Court Advocates Association,
ಕೊಡಿ 27952 ಕೊಡಿ.
27952.
Who are the respondents in that?
Respondent is
AGA.
First respondent, the second is the Advocates Association Bangalore. That is respondent number 2.
ಇವ್ರಿಗೆಲ್ಲ ಹೇಳ್ಕೊಳಕ್ ಒಂದ್ 4 ಸರಿ ಹೇಳ್ತೇನೆ, ನೋಡೋಣ ಏನಾದ್ರು ಜಾಸ್ತಿ.
228 Rohit Kumar. Wakalat has been filed only for 24528. What about 3? 3 Praveen Gowda, nobody is representing you. Praveen, nobody is representing you in this matter. Rohit Kumar for, he has filed Wakalatnama only for 24528. Nimge Wakalatnama hakilla.
My lord, kindly.
27952.
Kindly tell us the respondent number 5.
Rohit Kumar will undertake to file wakalat for Praveen Gowda.
Rohit Kumar, who has filed Wakalatnama for respondent number 24528. undertakes to appear for respondent number 3 also.
Lords,
Registry
4,
director print
5,
his name as such.
6, 7, 8,
ಅದು already file ಮಾಡಿದ್ದಾರೆ.
please.
4 to 8 is filed.
Already
Only
represented.
Praveen was left out.
Please, my lords.
Kindly tell the respondent number 5 and 6. He is from Kolar Taluk and as well as Chintamani Taluk.
ಆಯ್ತು.
They have filed the complaint before the district registrar Bangalore.
So you argue the matter.
Yes.
You are ready? Ravi Shankar?
Yes, my lords.
Yes. What is the relief? Or both of them should be taken up together?
Sorry, my lords.
Both the petition to be taken up together or
But
you
there
argue
may be
this
some
today?
overlapping circumstances. If your lords were to take both the matters together, it will be helpful because otherwise there will be some duplication. my lords.
Why waste time today?
It will be,
All the councils submit that the settlement talks have failed. Hence, they would be addressing arguments in the matter. They are directed to file their respective synopsis of dates and events, list of authorities, along with authorities, as well as synopsis of arguments after serving a copy thereof on the other council. Yavaga?
Next week, any date.
Released on 20th August.
please, please.
Sir, next week, sir, synopsis will happen.
Okay.
ಅವತ್ತು ಶುರು ಮಾಡಿ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮುಗಿಸಿ.
21st, is it?
20th August ಏನಪ್ಪ ಇದು ಅದೊಂದೇ ರಿಟ್ ಪಿಟಿಷನ್ ಇರ್ಲಿ ಸ್ವಾಮಿ, 2 ರಿಟ್ ಪಿಟಿಷನ್ ಮುಗಿದೋಗಿದೆ ಸ್ವಾಮಿ.
ಎರಡು ಇದೆ ಅಲ್ಲ?
Any date.
ಇಲ್ಲ 2 ಬೇಡ ಸ್ವಾಮಿ, ನಮ್ದು 2 ಮುಗಿಸ್ಬಿಡಿ, ಇದು ಒಂದು ಇರ್ಲಿ ಸ್ವಾಮಿ ಅಷ್ಟೇ ಆರ್ಗ್ಯುಮೆಂಟ್ ಗೆ.
ಯಾಕೆ?
ಯಾಕಂದ್ರೆ ಅವರು ಕೂಡ ಮೆಮೋ ಪಾಸ್ ಮಾಡಿದ್ದಾರೆ, ಅದನ್ನ ಬಾರ್ ಕೌನ್ಸಿಲ್ ದವರು ಮೆಮೋ ಪಾಸ್ ಮಾಡಿದ್ದಾರೆ.
ಎರಡು ಕನೆಕ್ಟೆಡ್ ಮ್ಯಾಟರ್ ಇದೆ, ಎರಡು ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿ
ಮಂದುತೇಶ್ ಮಾಡ್ತಾರೆ, ಎರಡು ಮಾಡ್ತಾರೆ.
ಅವತ್ತೇ ಆರ್ಡರ್ ಆಗತ್ತೆ ಅಂತೇನಿಲ್ಲ, ರಿಸರ್ವ್ ಮಾಡಿ ಮಾಡ್ಬೇಕು ನೀವೆಲ್ಲ ಇದು ಹೇಳಿದ್ರೆ.
ಆಯ್ತು ಸ್ವಾಮಿ.
ಅದು 20th ಒಂದಿನ ಬೇಡ, 21st ಮಾಡ್ತೀನಿ.
21st Friday,
20 ಅಲ್ಲ, I'm
21st
sorry,
ರಜಾ,
19th.
19th.
ಆ ವಾರ ಇಲ್ಲ ನನಗೆ. ಅವ್ರ ಅಧ್ಯಕ್ಷ ಸ್ವಲ್ಪ
ಅವ್ರು ಏನಕ್ಕೆ
ಅದು ಕೆಲವು ಡಿಸಿಷನ್ಸ್ ವಿ ಕ್ಯಾನ್ ಟೇಕ್ ಆನ್ ಅವರ್ ಓನ್ ಫೀಟ್, my lords.
24th?
24th,
24th.
please, my lords.
24. Okay.
Serial number 9, T.N. Harish, connected matters.
Yes, 9.
Matter, my lord, I appear one of them.
Mr. Sharma?
Yes, my lord, this is regarding concessions during the COVID period at KSRTC canteens. I'm also one of them. And
ಕೊರೋನಾ ಟೈಮ್ ಅಲ್ಲಿ ಇದ್ದು ರೆಸಲ್ಯೂಷನ್ ಮಾಡಿ ಅದು ಸ್ವಲ್ಪ
ಅದರಲ್ಲಿ ಒಂದು ನಂದು ಅಡಿಷನಲ್ ಏನ್ ಮಾಡಿದೆ ಅಂದ್ರೆ ದೇ ಫೈಲ್ಡ್ 2 resolutions subsequently that is challenged by me. I have amended the petition, already amended. That's all the additional. All other things ಅವರೆಲ್ಲ ಹೇಳಿದ್ದೇನೆ, same thing. The concession during COVID period. They could not have withdrawn it after giving.
You have carried out the amendment and filed amended petition?
Yes, on 7th I have done it. I have not, office notice, I think it is not noted. 7th I have done it. And amended petition also. I have
7th of
filed already.
August?
Yes,
7th
my
of
lord.
August or 7th of when?
3 days back or 4 days back.
7th of August ನೋಡಿ amendment ಮಾಡಿದಾರ 9.
ಮಾಡಿದ್ದೀನಿ.
Yes, filed the amended petition. Amendment.
Yes, I have, ಅದು ಮಾಡಿದ್ದೀನಿ. This is relating to, your lordship kindly say the KSRTC file.
Just a moment, please.
Yes, my lord.
Lord housekeeping. ಮಾಡಿದಾರ. The counsel for the petitioner submit 9.4. Submit that he has carried out amendment and filed the amended petition.
Yes, sir.
Perusal of the papers indicates that amendment has been carried out, amendment petition has been filed. Hence, office objection stands overruled.
Yes.
Non-filing of additional SOB by additional SOB?
I'll file it tomorrow, yeah. 2 days. One nimsha. So far as Sharma's petition is concerned, it does not fall in the other category. It may be separated, rest of the matter can be.
ಇಲ್ಲ
Now that
category
the
same.
tag is argue the matter now D-tag ಗೆ ಅದಕ್ಕೊಂದು argument.
So far as Sharma's matter is concerned,
You want to file your additional SOB or you will argue the matter?
we'll argue the matter.
ಮತ್ತೆ ಎಲ್ಲ arguments ತಗೊಳ್ಳಿ.
ಅಲ್ಲ, one submission I want to make, one submission with the permission of my learned friend. One day submission. He filed objections along with the 2 documents and another affidavit. Those 3 documents are filed during the pendency of the proceedings, and I am challenging that also. That is why I made the amendment with the permission of the court. Amendment was allowed. Now his statement regarding this is already there in his objection statement and the affidavit. It is already there. They could not have withdrawn it subsequently, and the resolution
No, for what
without
purpose are
hearing
you
us
making this
was
submission,
acted.
Mr. Sharma?
That's all the additional
For what
submission,
purpose?
nothing else.
For what purpose are you making this submission?
Because they have passed the resolution subsequently. That is why.
That you will have to
They could
address
not have
arguments
done
on
it
the
without
merits of the
hearing.
matter.
Yes.
Yes. Yav file tone.
Minutes it is the same as that. Others.
So far as if my lord were to take up my Sharma's matter, 741. It does not fall in
7641.
the general category, it falls in the other category. It does not come in the
Yes.
contentions raised in the other petitions, sir.
Yes.
It has a different facts of the case.
Yes.
ನಾನು ಮಾಡ್ಲಾ ನೀವು ಮಾಡ್ತೀರಾ ಶರ್ಮಾ ಅವರೇ?
Yes.
Mr. Sharma, nim submissions ಮಾಡ್ಬಿಡಿ 9.4.
ಮಾಡಿ ನಾನು ನಿಮ್ಮ I will make your argument. ನೀವು submission ಮಾಡಿ sir, you argue your matter.
Yes. Yes. What I am submitting is this, my lord. Whatever submitted by others also will apply to me so far as COVID period concession is concerned. I am
Yes.
also a commercial establishment. During that period, lot of things have taken place which the other advocates have also argued. During that period, because of the closure, there were concessions granted. As per the concession granted, we worked. Then I surrendered the possession. Now I am not in possession. And thereafter, my lord, for returning the security deposit, they said that there is a resolution passed that interest has to be waived or not to be waived, etc., etc. They did it. I am submitting that those resolutions passed without hearing us, without calling for objections, they are all not proper. Once they have given concession and we have acted upon that, and we have already paid the entire amount, not even rupees due to them. So entire amount is to be refunded to us, security deposit. That is all my case. Now they have, during the proceedings, they have refunded some amount. That amount also I have filed memo. The balance they have to refund. That is all my case, my lord. That is what I am submitting. The other categories all are same. During the COVID period, concession was granted. Now they say that we are withdrawing or reducing, etc. That could not have been done. That is the case, my lord. And now the last resolution passed. I am saying that they could not have passed such a resolution without hearing us and without giving opportunity to us. And we had made representations saying that it could not be done. Those representations are not heard, and they passed unilaterally resolution. That's what my submission.
Yes, Mr. Rana.
Yes.
And they are annexures R1, R2, R3 filed by them. This is one I am challenging additional. That is filed by Mr. Surana during the course of the proceedings. Exhibit annexures R1, R2,
Which the
R3
others
filed.
have challenged earlier. So you have challenged?
Yes. That
Yes.
is challenged now.
Yes.
So far as this petition is concerned,
Michael Matadi, so that he can also, Mr. Sharma can hear you.
ಏನಾಗಿದೆ, the entire place is occupied with government files. We have no place to stand also.
So you'll be encroaching on government property.
And if I encroach the government property before the court, straight away contempt.
194. Yes.
Kindly take my statement of objection at page paragraph 3. That will give the facts of the case.
Yes.
The petitioners was a participant tender proceedings for allotment of a hotel premises in the bus stand premises of Mysore.
Yes.
The tender was accepted on 20th 4/20. My lord will get it at page 3 of my statement of objection.
Tender was accepted on 24/2020. Yes.
20. Because of the COVID period, the agreement was executed on license was executed on 24/12/2020. 8 months after the COVID was over.
First wave was over.
First wave. It has become normalized, and therefore he came forward to execute the agreement. Can't be said that he was not aware of the circumstances were normal on that date. So after executing the agreement,
Or COVID was there earlier, so there's no intervening circumstances.
but COVID last in the month. See, concession was given in those period for few months. April, March, 10 days concession was given. That is, lockdown was imposed on 23rd March. April concession was given. May was some percentage was given. June was completed. After June and August, no concession was given.
So concession was given only for the lockdown period.
Lockdown period. At that point of time. Now he executed the agreement after the
Lockdown period.
situation stabilized and the circumstances became normal. That is on 12/24/12/20. Then he gave a letter, kindly turn to para 4. On 10/11/22, he gave a letter terminating the license.
11/1/22.
11/1/22. The circumstances were also normal then.
Yes.
So if the termination were to take place at the instance of the licensee, then the kindly turn to the agreement produced by my friend. At page 16.
Yes.
Paragraph 4.
Yes.
4.2.
ಒಂದು ವರ್ಷ ನಂತರ
ಒಂದು ವರ್ಷದ ನಂತರ ಪರವಾನಗಿ ಅವಧಿ ಪೂರ್ಣಗೊಂಡು ಕರಾರನ್ನು ರದ್ದುಪಡಿಸಲು ಇಚ್ಛಿಸಿದಲ್ಲಿ 4 ತಿಂಗಳ ಮುಂಚಿತವಾಗಿ 1ನೇ ಪಾರ್ಟಿಯ ನೋಟಿಸ್ ಅನ್ನು ನೀಡಿ ನಿಗದಿತ 4 ಮಾಸಿಕ ಪರವಾನಗಿ ಶುಲ್ಕ ಹಾಗೂ ಇತರ ಶುಲ್ಕಗಳನ್ನು ಪಾವತಿ ಒಪ್ಪಂದ ರದ್ದುಗೊಳಿಸುವರು. The 4 months period is fixed because we can't grant the premises to anybody as a private party can do. We have to invite tender. It will take 3 months time, and thereafter 1 month time will be given for redevelopment and all that, and therefore 4 months time is fixed. Now, if they want to cancel the agreement in 4 months time, they have to give 4 months notice. He did not give the 4 months notice. He terminated the license with effect from 18/1/22.
Yes.
It was a normal circumstances. It was not a COVID period. So therefore, we deducted 4 months license fee and refunded the license fee to him. Balance license fee. My lord, may kindly turn to page 4.
After deduction, 4th month license fee, everything else.
Everything is there. Kindly turn to paragraph 5. His license fee was to be deducted up to 18.5. Petitioner's advance amount, which was liable to be refunded, is refunded by issuing a check for which 10,19,317 dated 11/1/23 bearing check number so and so. The petitioner accepted the same in lieu of the claim for refund of security deposit. Under the circumstances, he cannot make any grievance now. So therefore, what is done is an according contract. There was no question of applying COVID concession to this case will not raise up.
Yes.
That's my submission.
What about them?
Yes. Idralli similar type of cases are there in regard to 2 petitioners. I will request my lord to take up those cases, cases.
Yeah.
That is in the case of Damodar and others.
9.3 Kodi. 20426.
Yes. In that case also, 9 and 10, they fall in the category of the case of my friend Sharma.
9 and 10 are vacated.
9 and 10. They prematurely surrender the license and therefore they are liable to pay the amount.
Yes.
Paragraph 11 of my statement of objection. Same conditions are there
Hmm.
with regard to the petition number, this class number, petition number 9.
Yes.
The agreement is at annexure E11.
Hmm.
E11. He terminated the license by issuing a notice.
This is 6 months.
6 months. So therefore,
Where is that clause?
agreement is at A11.
Page number.
Pande. A11
Hmm.
and the class is at 157.
Clause 9.
Class 9. ಯಾವುದೇ ಕಾರಣವನ್ನು ನೀಡದೆ 4 ತಿಂಗಳು ನೋಟಿಸ್ ನೀಡಿ ಮಳಿಗೆಯ ಪರವಾನಗಿ ರದ್ದುಪಡಿಸಲು ನಿಗಮವು ಅಧಿಕಾರಗೊಳಿಸಿದೆ. ಪರವಾನಗಿ ಪಡೆದ ಅವಧಿಯಿಂದ 1 ವರ್ಷದೊಳಗೆ ಪರವಾನಗಿದಾರರು 6 ತಿಂಗಳ ಮಾಸಿಕ ಪರವಾನಗಿ ಮುಂಗಡವಾದ ಪರಿಸ್ಥಿತಿ ತಮ್ಮ ಪರವಾನಗಿ ರದ್ದುಪಡಿಸಬಹುದು. 1 ವರ್ಷದ ನಂತರ ಪರವಾನಗಿ ರದ್ದುಪಡಿಸಿದ ಪರವಾನಗಿದಾರರು ಇಚ್ಛಿಸಿದರೆ 4 ತಿಂಗಳ ಮಾಸಿಕ ಶುಲ್ಕ ಮುಂಗಡವಾಗಿ ನೇಮಕ ಪಾವತಿಸಿ ರದ್ದುಪಡಿಸಬಹುದು.
This is also 4 months.
4 months.
1 ವರ್ಷ ಆದ್ಮೇಲೆ 4 months.
1 ವರ್ಷ ಆದ್ಮೇಲೆ 4 months.
1 ವರ್ಷ ಆಗಿದೆ ಅಲ್ಲ?
He 18/5/22 he gave a representation.
Hmm.
The agreement is dated 15/12/20 after 1 month, after 1 year.
Agreement is dated
15/12/20 at 153.
15/12/2020. And the notice was given on
18/5/22.
so more than 1 year.
After 1 year, if it is 1 year, before 1 year, 6 months.
6 months.
After 1 year, you want to surrender 4 months.
4 months.
So 4 months license fee is liable.
In statement of objection, you have said 6 months, that is why.
We have deducted 4 months license fee and refunded the amount.
At para 11, you have said I have to pay 6 months license fee. That won't be correct, alright? It will be 4 months.
That is the general classes I have stated. I have stated.
So how much have you
in the
deducted
event
and
if
how
they want
much
to
have you
terminate
paid him?
license prematurely within 1 year, license fee has to pay the 6 month license fee. In the event licensee want to terminate license within 1 year, after 1 year, in that event licensee has to pay the license fee for 4 months. This class incorporated and all that.
Now you have deducted 6 months or 4 months?
If you have surrendered after 1 year, we will deduct 4 months license fee and the amount will have been refunded.
That is the ideal situation as per the clause. But what have you done? Have you deducted 6 months or have you deducted 4 months? Because your objection is indicating as if you have deducted 6 months.
No, I don't. I have not said so anything because the information was. not
License has to pay 6 months license fee.
there. He has surrendered the position. ಯಾವತ್ತು ಕೊಡಿ surrender ಹೇಳಿ ಇವರೇ?
ಎಷ್ಟು ಡಿಡಕ್ಟ್ ಆಗಿದೆಯಪ್ಪ? 4 months ಡಿಡಕ್ಟ್ ಆಗಿದೆ? Nothing has been refunded. No refund. So 4 or 6 we'll have to look into. Yes.
And 10 also. In this petition, 10 also similar condition.
This is R9, petition 9.
Petition. R10 also same position.
Petitioner 10 is agreement dated. What is the date of the agreement of the petition number 10?
10 ನಲ್ಲಿ annexure R12.
ಇದನ್ನ ಒಂದು ಸ್ಟೇಟ್ಮೆಂಟ್ ಮಾಡಿ ಕೊಡಿ ನೀವು. So it becomes easier. What is the date of the agreement? How many, when he issued the termination notice, which is the clause applicable?
I will give it day after tomorrow, 14th or 15th. Meanwhile, will
So your contention in for 9 and 10 is you are entitled to deduct 6
4
months.
months after.
What about petition number 1 to 8?
Others case is concerned, my submission is, it was only a temporary period of COVID. It is not that it is the permanent period, therefore the contract will frustrate. My lord is aware of two factors.
Contract is not frustrated, is your
Frustrated because it is a concluded contract.
frustrated the impossibility of performance, sir.
Like temporary, you see, obstructions will not be of frustration of the contract to put in it. There are two things. One is the frustration will take place. Party may express a desire that I am going to put an end to the contract and thereafter the contract will cease to exist. If that is not done, if the contract is continued, then he can't claim any concession. That is one submission I make.
Option of termination was not exercised, therefore it continues.
Continue. They did not exercise the option. Then the other is they depend upon a intra-department communication. All petitions are grounded on the intra-departmental communication. My lord may kindly take in my lord has the papers of 20426.
20426, yes. Page?
Page 167.
167.
67.
Yes.
Dated 3/8/20. It is an intra-departmental communication addressed to the divisional controllers by the chief commercial manager. All these petitions are grounded on this document.
You are relying on page number 177. 167 is
Same thing. See, these are all the intra-departmental communications, and ultimately it is for the board of KSRT to take a decision. If the communication is sent by the commercial manager to the divisional controllers, it is not that it is binding, it is a concession given to them. Ultimately taken the decision, and the government has also taken the decision, kindly turn to exhibit R1 and R2 in all the cases.
So these are not addressed to the, these are not addressed to the petitioner, is your contention.
Yes, it is the intra-departmental. I will give the judgment of Supreme Court also. And then not much on fact, there is no. Objection 204.
Statement of objection.
Page number 9.
Page number 9 is para 14 of your objection.
24,
24.
Damodar's case is there.
Yes.
Additional objections are given.
How?
204426.
How?
Paragraph page 9.
Paragraph 14. In page 9 ಅಲ್ಲಿ ಏನಿರ್ಬೇಕು ನಿಮ್ಗೆ?
Sorry, ma'am. First 11.
You want to refer to annexure R1. Yes.
Around 10283 of 44/7 meeting on 21/3/2022. Undoubtedly, a Tiffany model resolved the action with the full amount from the government and fund for the said period as set out by the board. The government also claims it is same difference with asking. Annexure article.
This proposal was given by whom?
The CCG, the recommendatory authority. It took the decisions and decision was communicated intra-departmentally. But ultimately, the decision was placed before the board for approval. The board did not approve it.
Proposal was by?
ವಿಷಯ ಪ್ರಸ್ತಾಪಿಸಿ ಅದು ಬೋರ್ಡ್ ನೋಟ್ ನೋಡ್ಬೇಕಷ್ಟೇ. ಪ್ರಪೋಸಲ್ ಬೈ ಹೂಮ್ ಹೌದು ಅಂದ್ರೆ ಐ ಹ್ಯಾವ್ ಟು ಪ್ಲೇಸ್ ಬಿಫೋರ್ ದಿ ಕೋರ್ಟ್ ದಿ ಬೋರ್ಡ್ ನೋಟ್. ಇಟ್ಸ್ ಓನ್ಲಿ ಎ ರೆಸಲ್ಯೂಷನ್. My submission is annexure B, my lord saw. Annexure B, my lord kindly say, is the decision taken by CCG. That is Central Core Committee, Commercial Core Committee.
Yes.
That decision was placed before the board for approval. The board rejected the decision.
And none of it had been communicated to the petitioner, so therefore they cannot claim any
benefit
under the internal communications, your submission.
Now kindly see, bear in mind, based on the internal department application, no rights can be claimed. I rely upon 2011 8 SCC 670.
Yes.
Kindly turn to paragraph 1. We are concerned with the legality of the direction given by the Revenue High Court of Uttaranchal at Nainital to the state government to pay the amount of 70,99,951.50 with interest to the respondent, placing reliance on the intra-departmental communication sent by the district magistrate Haridwar to the Secretary Government of Uttar Pradesh. Para, kindly turn to para 22 to 24. I will read only 22 minutes, 23. It is settled law that all executive actions of the government of India and the government of state are required to be taken in the name of the president or the governor of state concerned. In the case may be article so and so. Orders and other instruments made are executed in the name of president state, as the case may be, are required to be authenticated in the manner specified in the rule made by the president governor of India. Other words, unless the orders are expressed in the name of president or governor and it is authenticated in the manner prescribed by rules, the same cannot be treated as an order of the government or all. A noting recorded in the file is merely a noting simpliciter and nothing more. It merely represents the expression of opinion of the particular individual. By no stretch of imagination can such noting be treated as a decision of the government. Even if the competent authority records its opinion on the file and the merits of the matter under the consideration, the same cannot be termed as a decision of the government unless it is sanctified by the acted upon by issuing an order in accordance with so and so. Nothing in the file or even decision gets culminated to an order affecting the rights of the parties only when it is expressed in the terms of the name of President the Governor, as the case may be so and so. A noting or nothing decision recorded in the file can always be reviewed, reversed, overruled, and the court cannot take cognizance of the earlier notings or decisions for the exercise of power of judicial review. So and so judgments are stated. Then there can't be any estoppel when the act is unauthorized one. It is not they were not the authorities to give concession. I will place reliance upon two judgments of the court.
Yes.
First is Delhi. Para 27, page 9.
Yes.
Thus, if lease premises is rendered substantially or permanently unfit for the purpose for which it was let out, the lessee has option to
27
avoid.
is Raichur, Matam, Prabhakar and others. Antide.
Hello. 20 Delhi, 96. First
Correct.
statement.
Other
Ink page 7.
Ink page 7.
See, ink page 7 alli, they have extracted 108.
Yes, para 20.
20 alli.
20 adu.
20.
Yes. You 27 andralla.
Then in the next, then in the right hand column, after the extraction of the provision, this is what observed. A perusal of the above shows that provisions itself would apply only in the absence of a contractual stipulation. Further, on the occurrence of situations contemplated above, which would render the property substantially permanently unfit to be used for the purpose for which it was leased, and the option of the lessee, these will be void. So they have not accessed any option.
Yes.
Then kindly turn to para 27.
Yes.
Thus, if these premises is rendered as substantially and permanently unfit for the purpose for which it was let out.
27 is again wrong. 27
Page
is in Raichur, Matam, Prabhakar and others versus Rawatlal Dugar. 27.
Right. Ink page. Ink page.
Ink page 9.
Ink page 9.
27 and inna on para idea 27. No?
Para 27, bottom, left hand column, bottom.
Left. Oh, there's one more 27 here.
The extracted portion. Illi, right hand column, extracted portion.
Yes, this is a judgment. This is para 24, extract of Sangeeta Batra.
Yes. Kindly turn to page 27, judgment page.
The extracted 27.
Richu Mantra Prabhakar versus Ratnaval Dugar. The Supreme Court held that suspension of rent may be claimed by a tenant if the lease has been dispossessed. Thus, mere no non-use may not always entitle tenant to suspension of rent. Then kindly turn to para 32.
Para 32.
32. At page 11.
Yes.
A tenant's application for suspension of rent is thus liable to be rejected in as much as while invoking the outright suspension of rent on the basis of forthcoming event. It is clear from the submissions made that the tenant do not intend to surrender the tenant premises while holding that suspension of the rent is not permissible. In these facts, some postponement or relaxation in scheduled payment can be granted owing to lockdown.
Yes.
Then there is judgment of Calcutta High Court. There is no estoppel.
Para
9 alli page 70, ink page 17.
Yes, 9.
I have underlined it. For obvious reasons, the government and administration cannot, like an ordinary person, be stopped by the acts of numerous agents and officials, each performing its work in a limited sphere, which is specifically limited authority imposed on the very nature of the work. Then other judgment is of Justice Andhra Pradesh at 74 at page 23, para 54.
Yes.
Para 54 only last 4 lines in the right hand column. It is seen that the collector may not be competent to finally allot the shops and levy sugar quota without the prior approval of the government. The government has necessary authority to keep in abeyance or even cancel the provisional allotment which was sought to be made by the collector, because ultimate authority rests with the government. Application of doctrine of estoppel, therefore, in view of which we have taken about the law, is not possible. Then the last judgment I rely upon is that if a thing is to be performed in a manner known to law, it must be performed by The other judgment is 75 Supreme Court 2164 gave.
Yes.
In this also, para 21. At page 42, the petitioners also sought to take advantage of what they described as admission in the government's affidavit filed in connection with certain earlier proceedings of similar nature. Under the admissions, if any, which are mere expression of opinion with a context and also being rather vague, hopes, not specific assurances, and binding on the government to create an estoppel.
Yes.
The next judgment is 2016 8 SCC 652, para 52. Para 52, I have underlined it. Particularly in commercial contracts or bids leading up to the commercial contract, where stiff competition, it must follow the application principle laid down in so and so, that if the employer prescribes particular format of bank guarantee, etc., then 53 kindly done, has been followed in dozen of decisions rendered by the court, the Constitutional Court of India. The Central Vigilance Commission has accepted this principle, the modified form guiding process, where it mentioned that all organizations to evolve procedure accepted by bank guarantee and LDA. Therefore, only the procedure prescribed by the law is that the board has to approve it. When the board has not approved it, they cannot take advantage of the internal communication. That is not a communication addressed to them.
Yes.
And it is not their case that permanently the license has come to the end by virtue of the COVID. When you continue to operate, see, even though the COVID was there, certain skeleton buses were operated in some areas. In all areas, it was not stopped. Some in Bangalore, it was stopped completely because of the population and all that. In some areas, the buses were operated. Number two, it is not a permanent disability that is inflicted not to use the premises. It is only a temporary to use the premises. They were using the premises. Their merchandise was stored there. Their employees were using it. They were sleeping there and all that. There, it is not that they are deprived of use of the premises.
But they are not earning anything.
See, they earn more. For example,
you rented it out for them to earn.
What my lord says is equity. I do understand it, but I am so far as I am concerned. Kindly see, take the first petition. They are earning double the amount what they are paying. They have given the bills of the bills. They say we have given the 50% concession in the COVID period, and they don't want to pay even 50%. And judgment fresh petition is there.
Yaudu?
Is fresh petition adrally.
35,467. Harish
case.
Harish case. 35,467. Yes.
35,467 ಅಲ್ಲಿ they produce the annexure D. They say we have given the concession for the month of July at 50%. They don't say they have also it is not that they are using the premises. In this case, they have also permitted somebody else to use the premises.
So they have subleased it.
Subleased it. And what? They have not disclosed what is that they have earned during the COVID period from the sublicenses. They have collected according to them 50%. If 50% is taken into account, kindly see annexure D, 1,72 lakh rupees they have collected for one of the sublessee, then 8 lakhs, that amount to 14 lakhs, then another 7 lakhs, 74,000, Then another 20,000. Then 1,16,000. They are collecting the money.
Hmm.
And the lease was extended to them. In the first instance, the lease was only for 12 years.
Yes.
This was, concession was extended. Kindly see annexure B,
Page.
page 16.
One
27/6/2012.
1/6, huh?
Yes, my lord. 16, my lord.
Yes.
Annexure B.
Hmm.
15/3/25, concession is extended. When the concession is extended, it is not their case we have lost the money or we have suffered losses on account of COVID. If you have made the profit, you can't seek concession.
Hmm.
So therefore, my submission is based on the inter-department communication, they can't seek a writ directing us to refund the amount or reduce the license fee or not to pay the amount. Then my submission is there is no right to seek concession as enforceable.
No vested right.
No vested right. The agreement does not provide for any contingency where concession can be given or concession be offered.
Yes.
Now that is governed by section 32 of the Contract Act. 56 is a general provision which deals with the frustration of contract. The distinction is made by Supreme Court.
Contract Act.
How 32 is applicable and how 56 is applicable.
Yes.
Of course, that is not relevant for this purpose of the case. Just as an economic interest, if my lord.
They're not raised the issue about frustration. They have not raised it.
Very well. Therefore, when they have not raised the question of frustration of the contract, the liability cannot be avoided. If the contract provides for the remission under certain circumstances, then 32 can be invoked. If the contract does not provide for any remissions of the payment of license fee, then only provision available to is 56.
Act of God during the time that it cannot be
56,
performed.
Only 56.
Hmm.
There is no other provision as I know. Under 56, as the Supreme Court puts it.
But we have judgment.
Well, I will not read it. I will just leave for the information of the court.
Then we.
No, I am not relying upon this.
You are not relying on.
I am not relying upon, only for the information of the court.
Why waste people?
So, section.
You can use it in another matter where you want to use.
Now, what the Supreme Court has said is, if you want to put an end to the contract.
You're not relying on it, don't argue.
No,
only argue what you are relying on.
What Delhi court said is also supported by this judgment. The Supreme Court, the Delhi court has extracted the judgments of Supreme Court.
108 definition.
Yes. And it is said that it is only a temporary closure. It is not a permanent closure. Two things. Either you have to surrender the position and they say that I can't operate because of this reason. When you are not surrender, you want to retain the benefit. You can't take the concession. And none of the petitioners have supplied any information as to what loss they have suffered and what is the earning they have made.
And that cannot be gone into in a writ petition.
Therefore, my submission of all these petitions that deserve to be discussed. So far as the two concerned, 10 and 11, 9 and 10, in that Damodar's case, I think 9 and 10. Otherly, I believe they have surrendered the position after 1 year. After 1 year, if the refund
4 months you will deduct and you will pay the
4 months you will deduct, and if it is not refunded, you will refund. Subject to whether refunded has them not.
If not refunded, you will refund.
If not refunded, you will refund.
Two suggestions. That is the intra-communication and there is a requirement of board of supervisors. Correct. Can kindly see respond number 2. Respond number 2 is the chief traffic manager commercial of transport department.
No, he may be whoever, but he is not addressed. He has not addressed anything to you. The distinction that Mr. Surana is trying to make is, even if we had addressed it to you, probably vicarious liability, and yes.
Not intra submission. My submission is not an intra submission, it's a direction by the
Sure.
authority to implement that order. Just kindly see, the second respondent is the person with the authority to rent out the premises. And the agreement will be executed by the divisional control of the road transport department. That is the third respondent.
Yes.
Now kindly go to page number 167, annexure D.
In which petition?
Not in my petition only.
NIM petition.
20426.
20426, yes.
Lordship,
Page?
Annexure D, page 167.
167.
But this was the concession given during the first wave of COVID.
Annexure B.
Annexure D 167.
Yes.
And the Lordship will see at page number 168. This is not direction given by second respondent. And this is addressed to Ella India Vibhagiya Niyantrana Adhikarigulu. But that is the reason I stated the authority to rent out the agreement is the second respondent, and the agreement will be executed by the third respondent upon his direction. And in this communication also, direction also, Lordship will see last line. ಮೇಲ್ಕಂಡಂತೆ ಕೈಗೊಂಡ ನಿರ್ಧಾರಗಳನ್ನು ಜಾರಿಗೆ ತರಲು ಹಾಗೂ ದಾಖಲಾತಿಗಳು ಅಗತ್ಯ ಕ್ರಮಗಳನ್ನು ಕೈಗೊಳ್ಳುವಂತೆ ತಿಳಿಸಲಾಗಿದೆ. And in this not page 167, third para Lordship will see. This is not an individual decision, it's an administrative decision headed by a commercial core group where the managing director has participated under the presidency of managing director.
Where is the managing director's present?
Not that page 167, Lordship will see third paragraph. ಈ ಎಲ್ಲಾ ಮನವಿ ಅಹವಾಲುಗಳು ಸಂಬಂಧ ಮಾನ್ಯ ವ್ಯವಸ್ಥಾಪಕ ನಿರ್ದೇಶಕರ ಅಧ್ಯಕ್ಷತೆಯಲ್ಲಿ ದಿನಾಂಕ 7/7 ನಡೆದ CCG ಕಮರ್ಷಿಯಲ್ ಕೋರ್ ಗ್ರೂಪ್ ಸಭೆಯಲ್ಲಿ ವಿವರವಾಗಿ ಚರ್ಚಿಸಲಾಗಿದೆ. Not that he has taken independent decision. Matter was placed in the commercial court group under the presidency of managing director. Decision was taken and direction was given. And the second respondent is the person with the authority to issue this direction. He is authorized to rent out the premises and to collect the rent. But now, Lordship is given the annexure R9, what they rely upon the resolution. It is only on the statement of the managing director they want to withdraw this concession given to them. Annexure R9 is there for
R1.
R1 ಅಲ್ಲಿ
R1 is
back to the committee.
the board resolution.
ನಿರ್ದೇಶಕರು ಅವರು ಮಾತನಾಡುತ್ತಾ ಇಂದಿನ ಮಂಡಳಿ ಸಭೆಯ ನಡವಳಿಕೆಗೆ ಸರ್ಕಾರದ ಹಣಕಾಸು ಇಲಾಖೆಗೆ ಪ್ರಸ್ತಾವನೆಯನ್ನು ಈಗಾಗಲೇ ಸಲ್ಲಿಸಲಾಗಿದ್ದು ಹಣಕಾಸು ಇಲಾಖೆಯ ಪ್ರಸ್ತಾವನೆಯನ್ನು ಸರಳವಾಗಿ ಸಭೆಯ ಗಮನಕ್ಕೆ ತಂದರು. ನಿಗಮವು ಆತ್ಮಸಂಕಟವಿರುವುದರಿಂದ ನ್ಯಾಯಾಲಯದಲ್ಲಿ ನಿರ್ದೇಶಕರು under the presidency of take the decision.
But these are all financial implications. The FD has to approve everything. That is the rules of business.
But my submission would be the direction and the page 1.
Has it been approved by the finance?
Not my another folder submission. So given in the first way of COVID. And the not the second annexure B at page 177. The first paragraph itself they extract the circumstances. Not they say not from 7/4/2021 to 21/4/2021 there was employee strike, and from 21/4/2021 to 22/2021 there was.
Where are you reading? What are you referring?
Annexure D page 177.
137.
177.
177. This is your association representation.
Based on the representation, but the circumstances are the same.
This is 23/8/21, Mr. Sarvana. Much after that. 176 is 23/8/21. 177. Yes, 177 ಏನಿದು?
But in that one first para itself, the circumstances not there specified. ಮೇಲ್ಕಂಡ ವಿಷಯ ಮತ್ತು ಉಲ್ಲೇಖಗಳಿಗೆ ಸಂಬಂಧಿಸಿದಂತೆ ಏಪ್ರಿಲ್ 2021 ಮಾಯೆಯಲ್ಲಿ ದಿನಾಂಕ 7/4/2021 ರಿಂದ 21/4/2021 14 ದಿನಗಳವರೆಗೆ ಸಾರಿಗೆ ನಿಗಮದ ನೌಕರರ ಮುಷ್ಕರ ನಡೆದಿದ್ದು ಬಸ್ ನಿಲ್ದಾಣಗಳಿಂದ ನಿಗಮದ ಸಾರಿಗೆಗಳು ಪೂರ್ಣ ಪ್ರಮಾಣದಲ್ಲಿ ಕಾರ್ಯಾಚರಣೆ ಆಗುವುದಿಲ್ಲ ಹಾಗೂ ಕೋವಿಡ್-19 ಎರಡನೇ ಅಲೆಯ ಭೀತಿಯ ಮುಂಜಾಗ್ರತೆಯಲ್ಲಿ ಸರ್ಕಾರವು ದಿನಾಂಕ 21/4/2021ರಿಂದ ರಾತ್ರಿ ಕರ್ಫ್ಯೂ, ವಾರದಂತೆ ಲಾಕ್ಡೌನ್ ಇತ್ಯಾದಿ ಕಠಿಣ ನಿಯಮವನ್ನು ಜಾರಿಗೆ ತಂದಿರುತ್ತದೆ. ದಿನಾಂಕ 27/4/2021 ರಾತ್ರಿ 9 ಗಂಟೆಯಿಂದ ದಿನಾಂಕ 12/5/2021 ಬೆಳಗ್ಗೆ 6 ಗಂಟೆವರೆಗೂ ಜನತಾ ಕರ್ಫ್ಯೂ ಘೋಷಿಸಿರುತ್ತದೆ. ಪುನಃ ದಿನಾಂಕ 24/5/2021 ಬೆಳಗ್ಗೆ 6 ಗಂಟೆಯವರೆಗೆ ಲಾಕ್ಡೌನ್ ಘೋಷಿಸಿರುತ್ತದೆ. ಏಪ್ರಿಲ್ 2021 ಮಾಯಲಿ, ಜೂನ್ 2021 ಮಾಯಲಿ ದಿನಾಂಕ 20/6/2021 ಲಾಕ್ಡೌನ್ ಮುಂದುವರೆದಿರುತ್ತದೆ. ಮೈಸೂರು, ಹಾಸನ, ದಕ್ಷಿಣ ಕನ್ನಡ ಮತ್ತು ಕೊಡಗು ಜಿಲ್ಲೆಗಳಲ್ಲಿ ದಿನಾಂಕ 5/7/2021 ಮುಂದುವರೆಯುತ್ತದೆ. ಈ ಕಾರಣಗಳ ಮೇರೆಗೆ ಏಪ್ರಿಲ್ 21 ಮತ್ತು ಜೂನ್ 21 ಮಾಯಲಿ ವಿನಾಯಿತಿ ಮೊತ್ತವನ್ನು ಇನ್ನಷ್ಟು ಪರಿಷ್ಕರಿಸಿ ನೀಡುವಂತೆ ಸಾಕಷ್ಟು ಮನವಿಗಳು ಜೊತೆಗೆ ಸ್ವೀಕರಿಸಲಾಗಿದೆ. But my submission is, in the same circumstances prevailing during the first day of COVID, and the very same committee member entered by the managing director, they have taken a decision and they have implemented. During the second wave COVID also, the situation was the very same thing. Now, and this was implemented. After lapse of 8 months, they want to say they have withdrawn from the resolution and we want to resolve the amount. That may not be correct. It was already acted upon.
They're not withdrawing. That is the distinction that Mr. Surana is making. The proposal which was there, internal communication, it was placed before the board and the board has rejected it.
Exemption during the first day of COVID. The situation and circumstances are the same thing. They couldn't have withdrawn our submission. And this is based upon our representation. This is what representation they have given. They have considered it and they have.
So that is your answer for that. Yes. In your petition.
ಯಾವುದು 27 ಯಾರು ಹರೀಶ್ ಅವರೇ?
Page 16. Yes. Yes.
And this is a completed contract once again. They never raised any objection while reviewing their contract. So now they cannot tell you, which is not the part of this agreement. Because at the time of reviewing this renewal agreement, they would have said that, we have given a wrong exemption to COVID exemption. You have to pay it back. That has not been done. So kindly see, they started issuing the notices from 1/8/2025 after the execution of this agreement. And the concessions were given from the month of April 21 to June 21. And in the notice, they would say that since the central office, maybe I make the new
53.
With reference to the above subject, due to COVID-19 pandemic, second wave, the exemption granted to the license holders of single agency for the month of April 2021 by the order of the central office, reference to the letter number 03, so you have to pay the penalty. So my resolution. Before that, there is already a completed contract. And the exemptions related to the year 2021.
Yes.
Then we are pending B1 act of God. And what are the circumstances and what should be taken? It is also under the agreement. That is Article 8.
Page?
Page 36.
36.
B1.
What document is this?
But one of the articles in the main agreement describing what are the effects of act of God by this agreement. In this regard, kindly see
Where is the full agreement? You can't give us 2 pages of it and say,
the original agreement. And this is extended from time to time. This is part of the original agreement.
does this extension refer to that document?
So this is not referred. The extension agreement is not is in continuation of the other, the 26, the page number 16. What they say is supplementary concession agreement dated they refer. This extended concession agreement is not affected.
And the original concession is 27/6/2012.
This is part of the first agreement. That is page number 36 that is referred. And the primary turns to page number 39.
Page number?
39, performance and obligation in case of affected party. Affected party, whoever is affected by the act of law. And just to look at the affected party.
Yes.
If the affected party is rendered only or partially unable to perform any of its obligations under this agreement because of personal event, it shall be excluded from performance of such obligation to the extent it is unable to perform the same on account of such personal event. So in this case, you have the total shutdown.
So we have not invoked it.
So even though there was under agreement also the exemption in the was provided and it has been granted to me. Because I am an affected party.
Yes. Is Mr. Sharma anything from your end?
Yes, my lord. I have the 2 points to make. Number 1, in my petition, please see annexure B. Annexure B.
Your petition is
7641.
3.
7641. 7641, my lord.
Hmm.
Your lordship got it?
Yes.
My learned friend's argument regarding 4 months deduction, etc., it is absolutely not based on facts. In fact, my notice was given in January. I vacated in June, and July they allotted to somebody else. So there was after 4 months or 5 months I have vacated, and 4 months notice was complied with. This is annexure B, their letter. Please
Where is
see,
the 4-month that you have issued?
my lord.
Where is the 4-month notice that you had issued?
That is referred to in this, my lord. I have given it. Annexure B. Would your lordship
Page?
see? Page 20 of the ink page.
Yes.
Please see. The reference is Nimma Patra 11/22. That is the notice my learned friend also referred to. Now, ಮೇಲ್ಕಂಡ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ತಿಳಿಯಪಡಿಸುವುದೇನೆಂದರೆ ಉಲ್ಲೇಖ ನಂಬರ್ ಕರಾರು ಇದರ ಪ್ರಕಾರ 4 ತಿಂಗಳು ನೋಟಿಸ್ ಬೇಕು ಅಂತ. ದೆನ್ ಉಲ್ಲೇಖ 2ರಲ್ಲಿ ಇದಾಯ್ತಲ್ಲ. ನಾವು ರಿಗಾರ್ಡಿಂಗ್ ದ ಉಲ್ಲೇಖ 2 ಏನ್ ಹೇಳ್ತಾರೆ ನೋಡಿ. ವಾಣಿಜ್ಯ ನಿಯಮಾವಳಿ ಕರಾರು ಒಪ್ಪಂದ ಖಂಡಿಕೆ 4(2) ಅನುಸಾರ ಕರಾರು ಒಪ್ಪಂದ ಮಾಡಿಕೊಂಡ 1 ವರ್ಷದ ನಂತರ ಪರವಾನಗಿ ಮಳಿಗೆಯನ್ನು ಖಾಲಿ ಮಾಡಲು 4 ತಿಂಗಳ ನೋಟಿಸ್ ನೀಡಿ ಕರಾರು ಒಪ್ಪಂದ ರದ್ದುಪಡಿಸಿಕೊಳ್ಳುವ ಅವಕಾಶ ನೀಡಲಾಗಿರುತ್ತದೆ. ಅದರಂತೆ ತಮ್ಮ ಮನವಿಯನ್ನು 4 ತಿಂಗಳ ಮುಂಚಿನ ನೋಟಿಸನ್ನು ಪರಿಗಣಿಸಿ 18/5/22ರಂದು ಉಪಹಾರ ಗೃಹವನ್ನು ತೆರವುಗೊಳಿಸಲು ಅಥವಾ ದಿನಾಂಕ 18ರ ಒಳಗೆ ಪರವಾನಗಿ ಶುಲ್ಕವನ್ನು ಈಗಲೇ ಪಾವತಿಸಿ ಮಳಿಗೆ ತೆರವುಗೊಳಿಸಲು ಅನುಮತಿ ನೀಡಲಾಗಿದೆ. ದಿನಾಂಕ 18/5/22ರವರೆಗೆ ನಿಗಮಗೊಳಿಸಬೇಕಾದ ಶುಲ್ಕವನ್ನು ನಿಗದಿಪಡಿಸಿದ ಕಾಲದಲ್ಲಿ ಕೊಡಬೇಕಾಗುತ್ತದೆ. ಒಂದು ವೇಳೆ ಕೊಡದಿದ್ರೆ ಎಟ್ಸೆಟ್ರಾ. Then, my lord, on 36 I have vacated. So I have given time up to 18/5. So 4 months notice was given. And I vacated on 36, and July in the new contractor is doing the business. Let him say factual situation, whether it is correct or not.
You have paid the rentals till June 22?
Up to 36. Entire thing I have paid. Let him confirm. I have paid till the date of vacating entire amount. There was no deduction at all necessary. 4 months notice was complied with. So this is a new argument, and it's not the case of the KSRTC so far. Now, your Lordship can say this is complied with. So that ground is not available to KSRTC.
Yes.
This is their reply to my notice. I have given notice. After that, 36 I vacated paying full, not even 1 rupees balance. That is not their case also.
Yes,
So that
Mr.
argument is not well founded and not
Anything else?
basis.
Anything else?
Number one. Number two, my lord. Now, this is what they have stated regarding this. Let them clarify factually if it is incorrect. Number one. Number two, my lord. I have filed a letter regarding the. He referred to the letter and the repayment in para. Would your lordship see his objection statement? His objection statement para 5. Just now he read para 5 of his statements. He is saying that through letter dated 11/1/11/23 they have refunded the amount. That letter I have produced. Your lordship may kindly see along with my because it was during pendency of the proceedings. 1/4/25 I have produced that letter along with a copy of the check. Would your lordship kindly peruse that in my file?
On when did you file it?
1/4/25. They returned the check during the they given the check during the pendency of the. I immediately sent a letter without prejudice because repetition is pending. Without prejudice, I received this amount. I have received. I filed a memo, reported to this honorable court about that. That is dated 1/4/25. Could your lordship see a memo along with the copy of the check and my letter? Your lordship got
No
it.
memo 1/4.
25. I have filed, my lord. Along with a
Memo-
copy of the check.
Well, and that is not 1/4, it is 17/4.
17/4, my lord. I am sorry. I noted it as 1/4. 17/4. That letter, your lordship may kindly see the first letter, what they have given. Your lordship got the letter, my lord?
Yes, 1/12/23.
Yes. 1/12/23. What they are saying is, we are deducting the amount which was shown as concession and the balance is being refunded, not 4 months notice. Please see that. The deduction is regarding reference to the concessions given and concessions withdrawn. And the total amount concession given which is withdrawn according to them. Next page you will also kindly see that letter. That is the amount they have deducted. It is not 4 months notice. And the check amount also you will also kindly see. Exactly, they have said the concession given is withdrawn because of the decision subsequently taken. So I am withdrawing it. So deducting that and balance refund is made. That is what they have been saying. Now my learned friend argues saying that 4 months deduction. Where is it? I do not know. I am unable to understand this argument.
Yes.
Now your lordship can see that my letter. Immediately I sent a letter saying that because the matter is pending in this writ petition, I am receiving it without prejudice and the balance has to be paid. So subject to the result of this petition and without prejudice I have received that.
Yes.
How can the 4 months notice will come? Absolutely, this is a
Not repeat, but don't repeat it. You can.
Next, my lord, this is what is concerned regarding this 4 months notice. Next one, next point, my lord, what he has stated regarding concessions.
Yes.
You are also kindly see. I'm sorry, I will not repeat it. This is so that ground is not available to my learned friend to argue now. Whether the concession given, whether it could be withdrawn or not, is the second point. Regarding that, my lord, one is everybody knows, even your lordship can see, even in the Supreme Court has given a particular period as a period of exemption for limitation. So everybody has suffered. Here it is not that we have not suffered. We can't say that we have not suffered. Then, my lord, during the period, whatever concession given, whether they can withdraw or not, is the only point now remaining.
Yes.
So in my case, that 4 months notice goal means only withdrawal. Withdrawal amount, my lord, I am submitting. A promissory estoppel, it cannot be against law. I will say, I will agree. But it's not there is no law prohibiting showing concession during an extraordinary period of COVID. There is no law. So promissory estoppel, I am saying there is an estoppel because we continue to operate so that we can make some amount, and because concession is shown in the license fee. Otherwise, we would have vacated. So we have acted upon that. Though the letters are internal communications, it is informed to us. Based on that, we have acted. Estoppel is against them. That is one thing. I agree. If they let them show any law saying that concession cannot be given by KSRTC or the licensing authority or the owner during such a COVID period where nobody expected. So that concession given is in accordance with law. There is no prohibition under law. So they are stopped from withdrawing that concession. Concession given is admitted. Withdrawal concession is this letter.
Yes, Ms. Sharma, you are repeating the same thing third time or fourth time now.
Then number 3, my lord. Third one, regarding the citations, my lord, I am sorry, it is my mistake. I am not present there. He did not give it earlier. I will reply to that because the citations given may not be applicable to a case of this nature where it is a vis major. Nobody expected that. That's why that the decisions would not apply to a case of this nature.
So, when will you reply on this citation?
Maybe any day convenient to your lordship, I will come there and I will reply that.
So far as my friend's case is concerned, he surrenders the agreement on 11/1/22, even before the CCG took the meeting. So the agreement has come to an end on 11/1/22. So the question of concession, he claiming the concession under that agreement, under that resolution will not rise at all. Then, now nowhere in the petition he says that the rents are paid after the issue of notice dated 11/1/22. Nowhere it says.
You verify that. Anyway, now that he is asking for time. Yes.
One minute. If he has paid the amount, I will accept it and see that it is given back to us. We don't want any.
And Mr. Sharma, you place on record from 11/1/22 to
Yes. June
22. If the rentals have been paid, you place the details thereof.
Certainly, if they dispute, it is a payment on record, my lord. Let him verify. If he says that it is disputed, I will show the payment.
You are making a positive assertion that you are paid.
Yes,
so you can place it.
Petition therefore I could not meet it.
You can place it on record.
Argument is concerned.
Otherwise, then you will tell about Mr. Surana. Mr. Surana will tell you it will go on for another.
Only 1 minute. So far as 35,467 is concerned, my friend has read the vis major class. Now, vis major class is not worked out. Kindly go to para 8.3.2.
Yes.
At page 39.
Yes.
If the affected party is rendered wholly or partially unable to perform its obligation, I am reading 8.2.3 at page 39.
8.3.2.
Yes, madam. If the affected party is rendered wholly or partially unable to perform any of obligation under the agreement because of force majeure event, it shall be excused from performance of the obligation to the extent it is unable to perform the same on account of the force majeure event, provided the excuse from performance shall be of no greater scope than of no longer duration than the necessity force majeure. The affected party shall make all reasonable effort to limit the damages if any cause is likely to result. Then that is another condition. Then kindly see, they have to issue a notice. 8.4. If the affected party claiming the force majeure event has complied with the notice procedure under 8.3.2, any time period specified in the agreement for the performance obligation, including concession, shall appropriately extend for a period equal to that of during the effective force majeure event. So 8.2, they have to issue a notice, which has not been done by them. Nowhere in the petition they say that notice is issued.
Yes.
And there is one more clause. My friend has not provided the entire agreement. In the event if the force marriage event continues beyond 30 days, then both parties must decide to terminate the agreement.
You will have to show us whatever clause you want to rely upon. There is one more clause under now notebook.
Actually, my handicap is this. Renuka was appearing in this case. The copy was given to me last date of hearing. You have not also placed the objection there. I will place the complete agreement whenever Sharma wants to argue the matter. So that
You give
I
him
will not, and
you give him
also
a set of your citations so that we'll have it next week and complete it.
Yes,
Third,
I will come there and cite.
reply arguments of Shri P.D. Surana, Learned Counsel for Respond number 2. The rejoinder arguments of the counsel for the petitioner. Shri Narayan Sharma, Vaiki Narayan Sharma seeks for a week's time to make a submission on the citations relied upon by Shri P.D. Surana, released on 20th August.
20th, my lord.
20th August, you can finish it, Mr. Sharma. Interim orders,
Interim orders to continue.
Interim order.
wherever granted,
Now,
is extended till next date of hearing.
I request my friend to give, at least by memo, our
I
citations
will,
on the.
both of
no,
you
no.
sorted out. Both of you sorted out among yourself.
Yes, yes. I am only requesting him. I am sorry.
Yes, next.
Serial number 10, Siri Rajshekar.
Was appearing for the petitioner.
Yes.
My lord, Learned AG had submitted, informed me that they are unable to open the financial bid because the system is not permitting them. My lord.
I think they are filing an affidavit, I believe.
Yeah. Last order, my lord, 23/7/2026.
Yes, madam.
Serial number 11,
Appearing for the petitioner minutes.
ಏನಾಯ್ತು ಮಿಸ್ಟರ್ ವಿಶ್ವನಾಥ್?
Not for responding.
ಮುಗೀತಾ?
ಇನ್ನ ಮುಗ್ದಿಲ್ಲ. It is
ಇನ್ನ
on
ಮುಗ್ದಿಲ್ವಾ?
process.
ಯಾವಾಗಪ್ಪ ಮುಗಿಸ್ತೀರಾ?
19th, 18th, 19th. Otherwise,
ಇಲ್ಲ, you want a longer time?
no, my lord, we'll finish it off. Otherwise,
Both the councils submit that settlement talks are still going on. Released on 19th. 18th.
18th.
serial number 12, T. Sheshgiri Rao.
Appearing for the petitioner minutes.
Yes. Cooperative society.
Cooperative.
Special
Minutes. The petitioner is a member of the society minutes. I became the member of the society in 2005. And in 2006 millets, I have paid 8 lakh rupees towards allotment of site millets. They promised me to allot the site. And later on, I went to Florida, United States. And now I have given GPA to my father. And he is contesting the matter. And millets.
Copies for the respondent. Ms. Vidyalata. Which layout is this?
Judicial layout.
Judicial layout, which layout? Yalanka.
Jakkur Plantation Village millets.
Jakkur Plantation. Posed before a bench of which SDRJ is not a party.
Millets.
This we can't take it.
Serial number 13,
For the petitioners, my lord, I have filed NOC Wakalat for petition number 1 to 16. Register may be directed to register in the name of KB Naveen Kumar.
Is it on special order?
And 2 weeks may be granted.
It's on special orders. In which matter you filed Wakalatnama? There are 13 to 13.4. ಯಾವ್ದ್ರಲ್ಲಿ ಫೈಲ್ ಮಾಡಿದೀರಾ ನೀವು? 1 You have filed wakalatnama for the petitioner. There are more petitioners after 16.
Total 18.
So what about 17 and 18? We're not filed. Another. You can't file piecemeal for some of them. So we'll dismiss the petition against 17 and 18. As regards 17 and 18 against Allah. They're all represented by the same power of attorney. It's all represented by a power of attorney. You should be prepared to make your submission. It's a specially ordered matter. Shri 13, Shri BS, so and so submit that he has filed wakalatnama for respondent number 1 to 16, petition number 1 to 16. Registry direct print his name as such and continue name of Shri Cyril Prasad Pais as that appearing for respondent number, petition number 17 and 18. Shri BS Karthikeyan has appeared for respondent number 1, delete Pawan Kumar as that appearing for respondent number 1. K. Krishna for Deputy Commissioner, reconvey division. ನಿಮ್ಮ ಪಕ್ಕದಲ್ಲಿ ಇನ್ನೊಬ್ರು ಬರ್ತಾ ಇದ್ದಾರೆ.
Krishna
ಯಾರು?
sir, Krishna sir.
Krishna will appear?
Yes.
13.1.
Appear for the petitioners, my lords.
Report of the outcome of the meeting by AG.
I filed an IA, my lords,
So
for
there are
direction.
4-5
Where, my lords,
categories of the
respondents
matter are
7 to
connected.
8.
This is
Huge list, Lord.
Hanumantan Bala ಇದೆ ಇದು.
The all matter for 1 acre 34 guntas. All 100 people are fighting that they are the allottees. They have been granted Hakku
13.1 40. Non-filing of report of outcome of the meeting by AGA. Yeah, who is appearing in this one state? Jafar,
13.1 statement.
who is appearing? All three of you have gone that side. 13.1. You'll have to get instructions now because this is a specially ordered matter. There's some meeting you have to give us the outcome. IA 1 of 23 will be taken up along with the main. IA 1 of 25, some documents the petitioner wants to file. Any objections?
Yes, I've already filed, my lords. There is,
You are appearing for 1 to 44. Any objections? Who is appearing? Munish? Mithun? Any objections to this IA 1 of 25?
I'll file my objection. Not file my-
Production of documents gain up objection.
It's okay.
Any serious objection?
I need to, come on record.
IA 1 of 25 has been filed by the petitioner for production of certain documents. Accepting the reasons stated in support of IA 1 of 25, the said application is allowed, the documents are taken on record. Early IA 2 of 25 is allowed. Ajit, there's some objection on your wakalatnama.
my lords, there is some mismatch of the names in the, as per the cost title, it has not been entered, they have said, my lords. I'll clarify it, my
See
lords.
illa, names illa. There are 3 office objections on it. Shri PB Ajit, who has filed wakalatnama for P1 to P24, seeks for a week's time to comply with the objection raised on his
Please,
wakalatnama.
my lords, I have filed an application, my lords, for the direction. My lords, the respondent 7 to 18, my lords, in this petition, my
We
lords.
can't recognize you until your wakalatnama is on record. First comply with that. Even your application also has some objections, so do that. Office objection raised on NOC wakalatnama filed by SK Mithun.
I'll rectify that. I'll rectify.
The counsel for respond number 7 and 8 also seeks for a week's time to comply with the office objection raised on the NOC Wakalatnama filed by him. 13.2. On furnishing of PF. Who are respond number 7 and 8 in this?
R6 is Ajay.
IA 1 of 24 nodi 13.2 ಅಲ್ಲಿ 6206.
Appearing to petitioners, my lords.
Yes.
13.2. Kindly pose this matter for next week, my lords. There is having some medical issues.
These are all minor things where you have to be prepared, not senior.
I'll do it.
Who is respond number 7 and 8?
They filed an application to bring the allottees on record.
Allottees, so notice has to go.
And for one.
IA 1 of 24 has been filed to bring the allottees on record. 6, 7, hence 6 you have appeared, Ajay.
Yes, that's what I've appeared for 6, my lords.
You will
I'm
appear for
appearing
7 and 8 also.
My lords, that's this one. Lords,
Girish Rao you appeared for.
Yes, my lords, because I'm appearing for Mr. Girish Rao in 13.3 also.
Yes,
In 13
Ramanan and V. Uma Shankari.
My lords, if I can appear, my lords, I'll just verify because
Notice kodada ಏನು ಮಾಡಿ?
notice ತಗೊಳಕ್ ಕೇಳ್ಬಿಡಿ sir. If I'm appearing, my lords, I'll verify
Yes,
today.
you file that. IA 1 of 24 has been filed to bring on record the allottees. 3 allottees. Insofar as the proposed respond number 6 is concerned, Shri Ajay J. Nandalke has entered appearance. Reissue notice to proposed respond number 7 and 8, returnable by 21st September. Counsel for the petitioner is directed to make payment of necessary process fee and furnish copies by end of day 13th August. Yes, Mr. Counsel, by 13th August. Failing which the impleading application insofar as proposed respond number 7 and 8 will stand dismissed. Memo IA 2 of 24, direction filed by petitioner. IA 3. Counsel for the petitioner is granted 2 weeks time to comply with the office objection raised. If office objection are not complied by 25th, the petition will be liable to dismiss for non-prosecution. 13.3.
Comply.
2 weeks to comply with office objection on IA 1 of 24. IA 2 of 24. IA 3 of 24, you are appearing, Ajay.
My lords, I'm appearing for few of them. Mr. Vivek Holla is appearing for a few of them, my lords, and I think Mr.
Any
Mohan
objections to allow it?
My lords, insofar as we are concerned, it's already allowed, my lords.
ಮತ್ತೆ ಇನ್ನ ಪೆಂಡಿಂಗ್ ತೋರಿಸ್ತಾ ಇದೆ IA 3.
My lords, I have no objection. My lords, I'm already on record.
13.3 IA 3 ನೋಡಿ.
Just one minute. I'm not ready. IA 3.
Mithun, you have appeared for all the petitioners?
No, no, matter. No, I'm not appearing for all the petitioners. Only 1 and 2.
ಏನು ಪೀಸ್ ಮೀಲ್ ಅಪ್ಪ ಎಲ್ಲರೂ.
Only the 2 site owners have approached me.
ಇದು ಯಾವ್ದಮ್ಮ ಇದು 8055
Year 3 in 8C 13.3.
3. A3 allow ಆಗಿದೆಯಾ? It was allowed, Ajay?
To my knowledge, my lords, it was allowed before Lordship Justice Sanjay Gowda, my lords, matter that IA was allowed. My lords, suddenly the matter has come. My lord, I am not prepared.
We are seeing so many things which are pending.
But by next date, we'll be prepared. We'll update this court. My lord.
IA3 ಏನಾದ್ರು allow ಆಗಿದೆಯಾ?
This honorable court had directed a convenience compilation to be filed along with the synopsis, Lord.
That is after all these.
That is why, Lord.
Service ಆಗ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಹೆಂಗೆ? How will it be taken up?
Other matters are connected.
So you have no objection?
I have no objection.
IA3 had been filed to implead the subsequent purchasers on record. Notice has been served. Some of them have been represented by Shri Vivek Holla and some of them by Shri Ajay
My lords, the order is of 20th of February, my lords. 20th of February 2025. I was allowed. That's why I'm saying 20th of February 2025. Order sheet down.
8055 ನೋಡಿ 20th of February
2025. Last year.
you have the order copy is good.
Don't even put it.
IA3 of 24 has been allowed on 20/2/2025. Registry to verify and do the needful. IA1 of 26. Okay. 13.4. IA1 of 24 is allowed.
My lord, I appear for the petition.
IA2 of 24 will be considered along with the main. Memo filed by advocate for respond number 7 to 16 is accepted. The statement of objection filed by respond number 6 is treated as statement of objection filed by respond number 7 to 16. The next.
My lord,
We'll have to hear it. Here,
The service of notice ಒಂದು ಆಗ್ಬೇಕಲ್ಲ ಅದು ಯಾವತ್ತು ಹೇಳಿದ್ದು issue notice
13th August.
my lords, there is another connected matter with respect to the same survey number,
more.
my lords, where
Here
it is
the
the writ
number.
petition number is 13296 of 25.
birth code
Please, my lords.
connect with so and so 21/9 released on 21/9
13.1, my lord, 13.1, my lord, I was just informed. that we are supposed
13.1
13.1, we are supposed to hold a meeting with the BDA and the BBMP together. That has not been done.
So you hold it.
The deputy commissioner will hold it, my lord.
In the meanwhile, learned AGA to make a submission as regards compliance. 3/11/23.
BBMP.
The order is dated 3/11/23. You still have not complied.
BBMP, BDA and the deputy commissioner, my lord.
But I was told, my lord, before the principal secretary, some meeting which was held with regard to this very same survey number, whether all three were required to meet, and what there's some outcome, Lord, which is not made.
The respective councils for the erstwhile BBMP, now GBA,
GBM.
BDA, and learned AGA
Deputy commissioner.
are directed to place on record the outcome of the meeting held between these three authorities by next date of hearing. To relist on 21/9.
Notice, my lord, we are the beneficiary under the.
Lords, interim order may kindly be extended, my lord.
Interim order extended.
Lord, we are the beneficiary under the denotification, my lord, by the BDA.
Huh.
In respect of 1 acre 34 guntas is concerned.
You are appearing for 6 to 16 in that matter.
Meeting and without.
Gottilla.
Say our things. No, Lord, it was not at all concerned with the allottees. 79 people in 1 acre 34 guntas.
None of us know if the meeting took place.
Yes.
None of us know what is the meeting. Let them place it
Get
on
the
record. If you have
information.
anything to
Place it
say
on
about
record.
it, you can say it at that time.
Because, my lord, they are denotified. It is admitted fact.
So
In
that-
favor of the allottees. I have placed before this about the High Power Committee meeting held in the year 1984. Yes.
Notice is not served on everybody.
Please.
13.4 Ali, Sri J.C. Kumar has appeared for respond number 6 to 16. Delete Prasanna Kumar P as that appearing for respond number 6 to 16. That is the only order we can pass in that matter. Yes, next.
Serial number 14.
The interim order may kindly be extended, my lord.
Extended, Mr. Vachan.
Grateful, my lord, grateful.
Yes, my lord.
Yes, Mr. Kamath. What can we do? Or what can you do?
No, there can't be a legal solution for all problems.
All problems.
But then, my lord, I think in the,
Where is Mr. Mirji? Ah, you got merged with the government side there. Kenai, so what does your client say now?
My client does not want to give consent, please, notes. Does not want to give consent, please,
To
notes.
either of them?
No.
So we'll permit them to go for a donor.
Please, notes. That exactly is what we wanted to also bring it to your lordship's notice, please, notes. By going with the donor, still the child will be born out of a wedlock. And legally speaking, please not, the mother does not have the right, even under the Guardianship and Wards Act,
Cody,
to,
if you take such kind of a stand,
please not.
that only shows we don't even want to use the word.
Millards, because there is joint family properties are there, please millards. That is the only concern. And since
why
that is,
Mr. Parvez made that submission that they won't make any claim.
yes, please millards, but she may not have the right to waive off the right of a child which is born through wedlock.
That is provided your sperms are used.
Please millards.
That is provided your sperms are used.
No, but still it is a wedlock. Is wedding? The wedding is not dissolved, please millards. The marriage is not yet dissolved. So Section 8, please millards, prohibits her from waiving of those rights.
Wedlock. Accept the divorce.
Please millards.
Accept the divorce.
We are ready, please millards. We are ready, please millards.
You are not accepting.
There.
Then that's a problem for you.
Yes, please millards.
You should accept it. If he was asking, if he was opposing the divorce, then it would be mala fide. You don't want the divorce. You want the marriage to be subsisting. You want to use his sperm. You want to use his any. Correct, but then that will be an issue as what Mr. Mirji pointed out as regards the claim if the child raises. It's out of the during the course of the wedding.
Joint family ancestral property. With respect to these other properties, we are giving an undertaking that the child will not stay anywhere.
You cannot give the undertaking on the behalf of an unborn child. We got a little confused as who is asking for divorce. If he is asking for divorce, then you cannot have this.
The petitioner also, in the given legal framework, cannot claim that I will go for a donor. So long as she is in marriage, she can go for a donor.
We empathize with you, but your client's conduct of wanting both cannot happen.
There is a situation, where we are talking about divorce. There have been instances where over a period of time, reconciliation also is there. But till I wait for such time, what if I lose my chance of it?
That is why you have to make a choice now.
Their concern is only with respect to property, not for anything else. It is like holding a gun to my head and saying, you give me divorce, I'm going to give you consent.
Can you give an undertaking on behalf of the unborn child?
I cannot.
Then
Will there be something, in 18 years?
can we pass an order on that basis?
I can give an undertaking with respect to myself and my child, unborn child, saying that these are the things which can be taken care of with respect to the entire procedure of IVF and with respect to the expenses of the child. Saying that the child will not get maintenance.
There cannot be estoppel against doctor. Whatever contractually any document is created, there cannot be any estoppel against.
Milord, my sincere request, please millards, Section 8 of the Hindu law, please millards, of the Hindu Minority and Guardianship Act may be reviewed, please millards. Section 8.
Yes.
Section 8, please millards, powers of a natural guardian. The natural guardian of a Hindu minor has a power to subject to provisions of this section to do all such acts which are necessary or reasonable and proper for the benefit of the minor and for realization and protection on benefit of the minor's estates. But the guardian can in no case bind the minor by a personal covenant. Please millards, 2A, please millards, mortgage, charge or transfer, sale, gift, exchange or otherwise any part of the immovable property of the minor. B, lease. Same, please millards. Also 3, please may be observed, please millards. Any disposal of immovable property by a natural guardian in contravention of section 1 and subsection 2 is voidable at the instance of the minor or any person claiming hereunder. Further, please, my lords, no court shall grant permission to accept to the natural guardian to do so any act mentioned in subsection 2 except in cases of necessity or evident advantage to the minor. Now, please, my lords, this poses a question, please, my lords. The minor is not even there, please, my lords. Now, it will create a legal implication, please, my lords, where we are creating future litigation. Further, please, my lords, 5 shall I read, please, my lords? You don't.
That is why probably the act requires the husband and wife both to give the consent. And it only makes an exception for a widow or a divorcee. That is the exception. Legislature has probably thought of it, and this issue has been examined, and that is how it has been restricted. Because this issue will arise, and this issue cannot be sorted out today for what will happen 18, 20, or 21 years, 18 plus 3, 21 or 22 years down the line. So this is the law which is there.
Totally understandable, my lord. But at the same time, what has happened here is there is another claimant to his so-called estate. Already
maybe 1 or maybe 100, it doesn't
present, already present. And as per the, like how we are looking into Guardians and Wards Act, under the Indian Succession Act or the Hindu Succession Act, he can also will, saying that my property will not go to XYZ. There are options where things can be accommodated if it is with respect to the property. Joint family property, my lord. In the Art Act, there is a certain insulation for that.
Which is
it is very clear. Section 31, my lord. Section 31. Firstly, what is a commissioning couple? That is very important, which has been spoken before. Rights of a child born through assisted reproductive technology. The right born through assisted reproductive technology shall be deemed to be a biological child of the commissioning couple. And the child shall be entitled to all rights and privileges available to the natural child only from the commissioning couple.
Yes.
Not the ancestral or joint family property. with respect to the property of the commissioning couple, we are ready to give an undertaking, and also he can
You can
create
give
a will
only-
and
You
register
can give an
it.
undertaking only insofar you are concerned, which you are actually fighting.
Yes, my lord. At the same
Now,
time,
if you are giving a concession for a child that you won't want any property of yours.
yes, my lord. I'm the commissioning couple. Here, it is very clear. If at all there is a right vested with the child,
Mr.
it is
Parvez,
only with respect to
You are
commissioning
no
couple.
longer a commissioning couple. Your commissioning is gone with the consent gone.
Yes, my lord. That is exactly what I am talking
So the
about.
act
We
does
are
not-
estranged. We are estranged.
Act does not recognize a non-consensual commissioning couple. It does not recognize that.
Yes, my lord. It does not, but it at the same time is against my right to life also, which is guaranteed. My body, my privacy, I can conceive a child. My only question is, as mentioned earlier also, that you give me a divorce, take the consent. This is a total complex situation for your lordship and everybody present here. Because the law overrides my right, guaranteed, to have a child, to right to be a mother.
Nobody,
Right to be a mother, man. It is something which is, this law needs to evolve by interpretation.
if you have a child through another man and the claim is made as regard the estate, there could always be a defense available that this child is not the child of so and so, therefore will not have a right in the property.
Right to the property.
But if you take it as per the order of the court during the subsistence of the wedlock, it becomes a different issue.
Totally different.
There are issues which you cannot, none of us can bind the child with.
The point is, he also had enough money.
You can't have the cake and eat it too, is what we can say probably, but that is your choice.
My lord, there is no cake here, my lord. The point here is, this is a plea by a mother seeking an intervention and interpretation of the law. There is an overriding effect of the current legislation, but at the same time, the constitution also is there. Where do I go, my lord? And you know, the only option for me to become a mother is to give a divorce, to accept the divorce, which I feel there is a chance wherein during the course of litigation, there might be a reconciliation. We cannot overrule anything, my
Glad to
lord.
hear all of you. You get ready with your arguments.
Yes, my lord.
The concession is not there.
Yes, ma'am.
We'll require your assistance in this.
I'm ready. But in fact, for the writ petitioner to say that she would take a donor, the commissioning couple, the other party in the commissioning couple will have to be medically proven to be infertile. That's the only, not in ARP is a procedure which is recognized in law, and it has to be utilized only in a manner recognized in law. The petitioner cannot say, I want to be a mother. So the law has given certain remedy. So you have to use it within the four corners of it. So the only way that in a commissioning couple, if one of them wants to use a donor, it has to be only if the woman particularly wants to use, the husband has to be infertile. And I don't think that can apply. There is no such establishment that he is infertile.
And there's already sperms are stored.
Yes.
So it's not that
No,
the infertility issue will not arise.
Utilize ARP, it should be medically established that he is infertile. That is what the subsection clause J of section 2 says.
So that sperms are already stored, so there's no issue about that. That may not be relevant at all. But
Minutes, one submission minutes.
hmm.
Minutes, now that the husband is not infertile, she cannot seek a donor is what the learned ASG is
Right.
trying to
But
convey.
the act has also not envisaged the issue.
So either
about-
ways, they cannot take a donor because no divorce and no, he's not infertile. The husband rightfully can give a consent for the taking donor sperm only if he's infertile.
He's asking for a divorce, but divorce is not being
Please,
given.
Lord.
He
He's
says
asking
divorce, you can do whatever after that.
Yes.
But this problem is that if the child is born during the subsistence of the marriage, tomorrow it may result in another litigation, and how do we protect him?
And also, please, my lords.
Is the one asking for divorce, he is right.
Section 31 operates there.
But for the petitioner, so long as she is in marriage, two things she cannot do. One, use the sperm without his consent. Number two, take a donor sperm. That's also not permissible. Therefore, the choice for the writ petitioner is only one. Do it as a single woman. That's the only possibility. As a single woman, the writ petitioner has got every right to utilize the ART procedure.
And please,
It's a
my lord,
complex situation, my lord. Single woman means, I mean, in other words, it means to say, give a divorce.
Classic
Give a divorce.
catch-22 Joseph Heller story this is.
Paradox of.
and also, please, my lords, it will open up and it will affect the rights of the already existing child which I had from my previous marriage. Because no, it's not ancillary. This particular order will affect him also, please, my lords. Not only him as an individual, but all his legal heirs.
And moreover, the other question is, Lord, can in 226 can the court issue a direction to get a donor sperm, Lord, which would be inconsistent with the provisions of the law? That would be the issue.
Is there interpretation possible is what he is looking at. He wants
Interpretation,
to argue
because
on interpretation.
It's a
That
law.
may constitute judicial legislation.
No. My question here, I reiterate the same thing. Every legislation is for the benefit of the citizens. It is a
If
social and a legal issue, my
If
lord.
you want to take the benefit of the act, you have to take it as it is, not as what you want it to be.
No, my lord, I'm talking about the interpretation of the act
What
by
is the
intervention of this.
You get ready and interpret whatever you want. Let us see if that interpretation
Yes, my lord.
stands. It doesn't look like that it will stand.
Yes,
That is what Mr. Kamath is saying.
maybe posted on Sunday, we will argue this matter on merit.
The submission of learned counsel for respond number 6 on instruction is that respond number 6 is not agreeable for his frozen sperms to be used for the purpose of assisted reproductive procedure of the petitioner. His submission is also that during the subsistence of the marriage between the petitioner and respond number 6 is unable to issue any no objection.
Please, my lords.
Issue any no objection
Yeah.
for availing a donor sperm, since the apprehension on part of respond number 6 is that the child born during the wedlock between the petitioner and respond number 6, though not with the assistance of respond number 6, but by way of ART using the sperm of a third party, the child could be regarded to be a child born out of the wedlock of the petitioner and respond number 6, giving a right to the said child to claim a right in the properties of respond number 6, which would not only affect respond number 6, but a child of respond number 6 through the previous marriage. His submission is placed on record. When will you get ready?
Next week, my lord. Anytime, next week. my lord.
You will require to look into it and see what is there.
After 20th, anything.
This statement is over now. It is between us three.
In fact, there was a challenge, there has been a challenge to certain versions of the Surrogacy Act.
Hmm.
So Sadhana and I are extensively working, in fact, it's a right now.
20th?
20th.
We list on 20th at 2:30 p.m.
But there is one end of the list matter, my lord.
End of the list till tomorrow.
Surfing matter tomorrow. At the
ಯಾವ್ದಪ್ಪ? ಯಾವ date will be given?
surfing matter.
ನೀವು 123, 124 ಅಂದ್ರೆ ಆಗಲ್ಲ. Only what is being passed over will be relisted tomorrow. Whatever is end of the list will be relisted tomorrow, because you won't allow us to take you on the end of the list.
Lord, the end of the list, there is urgency is this, my lord. Prohibitory order has been passed. Today some event is scheduled. The petition, yes, my lord, today 6:30. That is the reason why, my lord. But all of a sudden they have, my lord, without notice, without hearing, this notice has been, the order has been passed at page 28. For 3 months, my lord, which is contrary to law, and this is squarely covered by the judgment of the coordinate bench.
What is this matter?
Lord, the prohibitory order has been passed by the deputy commissioner. In exercise of power under 163 of BNSS.
He has 19 cases as against him.
Cases are there, my
Habitual
lord, but the
offender.
prohibitory order should be in a manner known to law. It's curtailment of fundamental rights. It's squarely covered by the judgment of the coordinate bench.
You don't even tell us the facts. You are
Lord, the only prohibitory
squarely
order.
covered and the covered it.
My lord, prohibitory order has been passed.
You
He has,
to give us
he has
the
been
facts.
restrained from entering to Udupi district, my lord, the deputy commissioner.
Who are you? What do you want to do? Why do you want to get there? You don't want to say anything.
My lord,
Then we'll give them time to file objections. Let them file
today
it next
the
week.
event is there, my lord. That's the reason why.
Make your submission, Mr. Sham.
Hence, paucity of time, my lord. I was.
Then paucity of time we'll
Lord,
adjourn it. Make your submission properly.
Yes, my lord. My lord, petitioner is a social worker, my lord.
Yes.
Some false politically motivated cases have been registered. By taking advantage of that, my lord, now the prohibitory order has been passed, restraining him from entering.
How many cases are pending?
My lord, according to them, my lord, 19 cases are there.
19?
Yes, my lord. Among them, my lord, 7 cases ended in acquittal. 3, my lord, B report has been
Are
filed.
you a resident of Udupi?
My lord, my native is Udupi, my lord. Now I am residing in Davangere.
So why do you want to go to Udupi?
Lord, Udupi for, my lord, some events are there, my lord. Today there is a public
What event
function.
is there?
Lord, it is, my lord, Akhanda Bharat Sankalpa Divas, my lord. May I pass on the notice and also, my lord, the invitation copy. But adhere, this, whatever condition they have imposed, I will follow, my lord. There is no difficulty at all, my lord. If
Somebody is organizing function. Why do you want to go there?
That's a main. Lord, Satish Davangere. Diksuchi Bashu.
You are Satish Pujari.
Yes, my lord.
You are not Satish Davangere.
The same person, my lord. They named as Davangere. In Aadhaar card, his name is my lord, or
Aadhaar card only Satish.
Satish. His
identity is a problem.
No. Identity, same person, my lord. No difficulty.
Because Satish Davangere antidellappa.
Aadhaar card says Satish.
Same. Aadhaar card is at my lord annexure D.
Page 31.
Page 31, my lord. Satisha, son of Gopal Pujari.
What are the cases pending against the petitioner? What provisions?
Not all. This one, my lord, at page 24.
Yes.
Lord, Bidugade agide. Crime number 102, 341, 143, 295A. Then, my lord, 143, 147, 307, 295A. All these are acquitted, my lord.
Bidugade, Samapti, Bidugade. All of them have been closed. B report.
Yes, ma'am.
No, some are in the investigation
Five
stage.
cases are.
Some 4 of them left.
Investigation stage. We have even
acquitted.
Opened and rowdy sheet as against him. He is an auto driver, is what the report says, who also claims to be an activist. Every time, whenever he enters this Udupi place, he wants to incite the communal thing by giving a hate speech.
He has already participated in
And whoever was the
3-4
guest
events,
speaker,
my lord.
according to them,
None of
my
the places where
instructions are
cases
that
were
he's been replaced with somebody because of this order already. And Udupi is an extremely sensitive zone, my lords. Every time he comes, enters this Udupi jurisdiction, he comes out with the other something or the other. Even though he claims to be a resident of Udupi, he's relocated himself to Davangere.
What do you do in Davangere?
He's an auto driver is what my instructions
are. Social worker.
Auto driver or activist?
Auto driver by profession. Also social worker. But there is no cases, my lord, pending in Udupi at least, my lord. Then
so you want cases to happen in Udupi?
No, my lord, if, not that, my lord. Already, my lord, he has participated in 3-4 events. In none of the places, my lord, there is no allegation or
When did you
complaint.
last participate in an event?
Yavaga.
And why do you come at the last moment?
Yesterday, my lord, the night they served, my lord, during the midnight. They do midnight operations only. And they will not give any
It's
time,
available only in
breathing
the
time
midnight.
also. There is no show cause notice, no opportunity of hearing, nothing. Well, this was done on, my lord, 10th August. Newspaper report.
10th August.
I'll get some instructions with respect to whether
6:30 instruction.
he's already been replaced by somebody else. Is my instructions, my lord. This person presence is not required, and he's been replaced by somebody else. Is my
No,
instructions.
not.
As a speaker.
You're not given a notice. You're not done those.
Minutes. I'll get the minutes. 2:30 they move the matter. I've been given the file now. Tomorrow, first thing in the matter.
After the event,
I understand minutes, but I'm also my hands are tied minutes. I don't have the full instructions except for one order I could get where he's declared as an a rowdy sheet is opened as against him.
Natural justice, we have to allow it.
Minutes. Otherwise, so many cases. He has so much of antecedents in inciting violence. 307 attempt to murder cases are being booked against him. There are cases which are still pending investigation, my lords. And he's a resident of Davangere. He has no relation with Udupi. His own documents indicate that he resides in Davangere. The only reason why he wants to come back to Udupi is because of the fact that, and not the case that he has.
I'll ask them to hold one more function later for you. And AG accepts notice for respond number 1 to 4. And though the counsel for the petitioner submit that no notice had been issued to the petitioner before the impugned order had been passed, and additional advocate general submit that there are a catena of cases pending against the petitioner for various offences, and it is for that reason that the impugned order has been passed. By relying on the impugned order, he submit that there were more than 19 cases which had been filed against the petitioner. Though some of them have ended in acquittal and some in a B report, there are several which are still pending. Apart from this, there is no other case.
No, Lord, so he's been declared. It's still in vogue is what I'm being instructed.
The rowdy sheet has been opened against the petitioner in the month of
May 2017.
May 2017. No, you said some other cases apart from apart from 19.
I was not able to get the full instructions because even though if some other cases are there, I can produce those cases whatever are there.
Relist tomorrow,
please.
Serial number 133, my lords.
He is opposing so much, saying that there are so many cases, and your own document indicates 19 cases. 19 cases is not something you filed it. Are you denying all those 19 cases? Are you denying all 19 cases? How do we look at any person who has 19 cases against him? ಅದು ಯಾವ್ದಪ್ಪ ನಾಳೆ ತೋಳಿ ನಾಳೆ ಜಾತ್ರೆ.
I moved the memo in the morning minutes. Your lordship has given a date tomorrow. Now the matter is not being listed. My colleague has followed up with it. Again, they are denying to list the matter tomorrow. Although there is a memo that is in the air in the file.
Are there any compliances to be made?
No complaint.
Compliance ಇಲ್ಲ ಅಂದ್ರೆ ಲಿಸ್ಟ್ ಮಾಡಿ.
My lord, serial number 124, my lord. My lord, serial number 124, my lord.
ಫಾಸ್ಟ್ ಓವರ್ಸ್ ಎಲ್ಲ ನಾಳೆ ಮೇಡಮ್ ರೀಚ್ ಆಗಿದೆ ಸೀರಿಯಲ್ ನಂಬರ್ 47 ಫಾಲೋ ಅಪ್ ಮಾಡ್ಬೇಕು ಇನ್ನೊಂದ್ಸತಿ ನಾನು ಹೇಳ್ತೀನಿ ಕಳ್ಸಿನೇ ಆಮೇಲೆ ನೋಡೋದು ನಾನು ಅಲ್ಲ ಈಗ ಆಗಲ್ಲ ಇನ್ ಸ್ವಲ್ಪ ಹೊತ್ತು ಟೈಮ್ ಒಂದು 1/4 ಗಂಟೆ ಆಗುತ್ತೆ ಫಾಸ್ಟ್ ಓವರ್ಸ್ ಎಲ್ಲ ನಾಳೆ ಬಂದೆ ಹೇಳ್ತೀನಿ ಒಂದೇ ಜನರಲ್ ಆಗಿ ಒಂದಿದೆ ಅದು ಹೇಳ್ತೀನಿ ಲಿಸ್ಟ್ ನಂಬರ್ 1 ರಿಮೈನಿಂಗ್ ಮ್ಯಾಟರ್ಸ್ 2nd September second list 20th August fast overs tomorrow
ಹೇಳಿ ಮೇಡಮ್ ಅದೇನು ಬರಲ್ಲ ಬಿಡಿ